as stipulated with the state for a total of $50,000. Conditions of bond will be that the defendant will be placed on pretrial services with weekly reporting in person, GPS monitor at the rate of $1 per day, no contact with Dawn Hall, no contact with any witnesses, no trespass at the address in Baker, which is on the order, but I don't want to announce it for everybody.
Thank you, Judge.
All right, is that the state's agreement?
It is, Your Honor. That should be all for Mr. Madden, Judge.
Thank you, Mr. Mayor.
Thank you. All right, I'll talk to your mom. Judge, the next case I have is Franny Merrifield on behalf of Mr. Wigton in 25 CF 1366. Mr. Wigton is present and approaching. Judge, we have reached an agreement, if I may approach.
Yes.
Judge, in 25 CF 1366, Mr. Wigton is withdrawing his previously entered not guilty plea. He is entering a no contest plea to the terms that are listed in the agreement. Give the court the opportunity to review that.
That's a downward departure
Yes, Your Honor, it is.
based on?
Your Honor, as far as plea, but additionally, I would put out there, Your Honor, that Mr. Wigton has complied since 2005 with no violations, all violations. And the date that this was pointed out to him on the internet identifiers.
All right, Mr. Wigton, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, can you state your full name and date of birth?
My name is Joseph William Wigton, 11/28/79.
Okay. And Mr. Wigton, you're here in 25 CF 1366 on one count of failure to register an email identifier, which is a third-degree felony punishable by up to 5 years in state prison. Do you understand that?
Yes, sir.
I've been given a plea and sentencing agreement that, between you and the state that calls for you to plead no contest as charged in that case. In return, your sentence will be 6 months of community control, $40 per month cost of supervision, $518 in court costs. Is that the right amount? Verify that. GPS monitor pursuant to the JLA and maintain your registry requirements as required by the statute. Do you understand all that, Mr. Wigton?
Yes, sir.
Is that what you want to do today?
Yes, sir.
All right. Did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
And are you satisfied with your attorney's representation?
Absolutely, yes, sir.
And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
All right. Do you understand? Oh, I'm sorry. Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything in return for your plea?
No, sir.
Do you understand by entering this plea there won't be a trial of any kind?
Yes, sir.
Do you understand you're giving up your trial rights, which are on page 2 of the agreement that you signed?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation? Okay, and what is your plea as a failure to register an email identifier?
No contest.
All right, I'm going to accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty, 6 months community control, 40-month cost of supervision, GPS monitor pursuant to JLA, and maintain your current registry requirements per statute. 817 court costs. Do you understand that, Mr. Wigton? You understand the court costs are $817?
Yes, sir.
Does that change your mind in any way? No. Okay, just want to make sure that we've talked about it. All right, Mr. Wigton, I'm going to have you talk to probation, who's behind you. I have to have you fingerprinted, and you have 30 days to appeal. Ms. Merrifield, did I miss something?
Judge, I would just request the GPS monitor at the rate of $1 a day. Mr. Wigton does struggle with employment and with the court costs being elevated.
Okay. $1 per day on the GPS monitor.
Thank you, Judge.
All right, and it is a downward departure based on the uncoerced plea bargain and the reasons stated by the state that he's been otherwise compliant.
Thank you, Judge. I don't have anything further to say.
All right, thank you. Ms. Merrifield? All right, Mr. Durrell? Morning.
May it please the court, Dustin Durrell. My client today is Mr. Dion Green. We had left this one set. I had provided a counter plea to the state. They were attempting to contact the victim in the case. I don't believe that's happened yet. Speaking with Ms. Leone this morning, she indicated the court may have a date this Friday. If we could set it for this Friday, see if we can get in contact, see if we can get this case resolved, Your Honor.
Possibly, Your Honor.
Say again? Possibly?
Possibly, if we could put
Okay.
it for Friday.
All right, we can put you down for November 7th at 9 a.m. That's our jury review date, but obviously it's just for a plea or continue that day.
Yes, Your Honor.
All right. Is he here today, or?
He is not. We've waiver on file, Your Honor.
Okay, just wanted to make sure.
Thank you, Your
All
Honor.
right, thank
I believe
you.
that's all I have.
We'll see you Friday.
Thank you.
All right, Mr. Riosti? Morning.
Joseph Riosti for Christian Alexander Douglas, who's in custody. 2023 CF 111C. Present before the court and approaching. Your Honor, we have this set for jury selection on Monday and jury review on Friday, jury selection on Monday, and Wednesday and Thursday for the anticipated trial with an overflow on Friday.
I believe it'll just be Wednesday and Thursday, 2 days.
That's what I expect, Your Honor, but I said that it depends on defense's case.
Okay. All right, well, we'll figure all that for sure on Friday, once we know how many other trials are going. I expect that you'll be my priority for first week, because you asked for first week already, and then I just want to know if you're going to have to dip into Friday or not.
Yes, Your Honor. I filed, the state has filed 2 evidentiary issues, and I filed a response to both of them. They need to be heard.
Are they going to be heard on Friday?
I didn't see the response, so if you could just verify those. My assistant's out sick this morning, so if they came in, I haven't seen them yet.
Their defense's motion in limine, first motion in limine and second motion in limine. And they are in response to the defense, the state's motions.
The Williams rule
The
motion.
Williams rule motion.
We can hear them on Friday, but this is part of the issue in filing all these things late in the game. We have to push them to the last day possible. If we can, I just don't have any other time this week, unfortunately, because I know we've got Thursday full already, and Tuesday and Wednesday. I'm in civil all day, so we'll do it Friday, but
And one other matter, Your Honor, we discussed on pretrial the issue of the defense's expert. It's my understanding that Mr. Riosti does not intend on calling him because he hasn't shared his information with me yet.
I do not intend on calling the expert witness.
okay.
I have not listed him.
And this is regarding the phone?
Yes.
One more matter, and I can write a motion in limine if the court prefers. Mr. Riosti just mentioned to me that he may call a defense's witness that I didn't know about until this morning.
I had conferred with my client, and I've discovered a potential rebuttal witness. They're just rebuttal witnesses. They're not fact witnesses.
Rebuttal is usually what the plaintiff or state would be calling after the defense puts on its case. Rebuttal to what?
Rebuttal to anticipated state's testimony or an impeachment
Let's
witness.
just call it a defense witness.
Yeah.
I'm not sure why we're calling it rebuttal, other than to try to say it didn't need to be disclosed.
It has not been formally disclosed, Your Honor, just in talking to me right before.
Well, talk about it amongst yourselves, figure out if a motion needs to be filed. You can certainly do that. I'll make the decisions, I guess, on Friday, or we'll have to push it to the trial as far as once I've heard what it's allegedly in rebuttal to, I'll make the determination. But, when you already anticipate it as a rebuttal, it seems like someone that should have just been disclosed through discovery. All right, anything else?
No, Your Honor.
All right, just make sure, if you could, file notices of hearing on what you want to actually have heard on Friday, and make sure I have a copy sent directly to my office. I just don't want to take a chance I miss something and don't prepare for it.
Yes, Your Honor.
Yes, Your Honor.
All right, thank you. We'll see you on Friday the 7th. All I have, Mr. Rasky?
Yes, Your Honor.
All right, thank you. Mr. Stewart?
Your Honor, may I pass my case for a moment?
Yes, sir. All right, Mr. Catalinic, are you ready? It's okay. We'll just pass you. All right, Mr. Kleins, are you ready with yours? All right, Mr. Russell?
I have one in custody, Jonathan Collins.
That's what we'll do after you, Mr. Russell. We'll call the Zoom cases that I have set up so far.
Approach on Mr. Collins, Judge.
Sure. Responsible. All right, so on Mr. Jonathan Collins, that's 25 CF 1041 and
He's-
24 CF
He's not here,
2510.
Judge, yet. We can call Mr. Ewing.
Oh, he's not even here? Oh, he's right here, okay.
Judge, this is Jonathan Collins. Case numbers are 24 CF 2510 and 25 CF 1041. Based on the discussions at the bench, we would like to set it plea or continue for Friday.
All right, plea or continue for Friday, that's November 7th. You back on that day, Mr. Collins?
9 o'clock, right, Judge?
Yes, sir.
Okay. See you Friday. And then Mr. Ewing, he's present and approaching. For the record, his case number is 24 CF 569. And the same situation on Mr. Ewing, except he was set for plea or trial, so we'll leave him plea or trial for Friday. The state is still working on some things.
Okay. Did have any issue with plea or trial?
No.
Okay, just want to make sure that it's ready for a trial if it's not a plea on Friday. Plea trial on November 7th, 9 a.m. We'll see you back on that date and time, Mr. Ewing.
Thank you, Judge. That's all I have.
All right, Ms. Basso, oh, never mind. Mr. Stewart, are you ready?
Yes, Your Honor, if I may.
I've just got Ronald Johnson on Zoom. I was going to call that one because I thought it would be quick, hopefully.
May it
Go ahead,
please the
Mr.
court,
Stewart.
Your Honor, Brad Stewart, on behalf of Randy Bogus, Judge, B-O-G-G-E-S-S. This is 25 CF 818. Mr. Bogus is present before the court. And at this time, Judge, we are prepared to withdraw our previously entered plea of not guilty, tender plea of no contest to the amended misdemeanor charge of possession of paraphernalia. Judge, that is going to be an adjudication of guilt, 275 court costs within 90 days.
All right, you don't have a plea, written plea? All right. All right, Mr. Burgess, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? I do. Can you state your full name and date of birth, please?
Bogus Jr., 4/15/89.
All right, and Mr. Burgess, you're here charged with possession of a controlled substance, third-degree felony, punishable up to 5 years in state prison. Do you understand that?
Yes, sir.
All right, and I've been informed by your lawyer that you're going to be entering a plea to a lesser misdemeanor, which is? What was the-
Possession of paraphernalia, Your Honor.
Possession of drug paraphernalia, 893.147. You'd be adjudication of guilt, 200 and, is it 70 or 75?
I believe it's 75.
It's 270.
70.
Yes.
Very good.
$270 in court costs with 90 days to pay that amount. Is that what you want to do here today, Mr. Burgess?
Yes, Your Honor.
All right, and did you have enough time to speak with your lawyer?
I did.
All right, do you understand what the state's offer is that you're willing to accept?
Yes, Your Honor.
Are you satisfied with your lawyer's advice?
Yes, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? Are you understanding that there won't be a trial of any kind? Anyone force you to do this? Anyone promise you anything in return for this? Do you understand that since there won't be a trial, you're waiving all potential defenses that you may have?
I do, Your Honor.
All right, and what is your plea to the possession of drug paraphernalia? I'll accept your no contest plea as freely, voluntarily, knowingly given. Sorry, that goes back over here. Stole a person's language. To the drug paraphernalia, again, 893.147, and that's an adjudication of guilt, 270 in court costs, 90 day to pay those costs, Mr. Burgess. All right, I don't think I need your fingerprints. You don't need to talk to probation, so you have 30 days to appeal. Thank you.
Your Honor, that's all I have. May I be excused?
Sure.
Thank you, Your Honor.
Stuart, you're withdrawing, did you say?
Yes, Judge, for the record, we're withdrawing our motion to suppress on the matter.
Okay.
Thank you.
Go ahead and call our Zoom people.
Yes, Your Honor.
I'm not sure if I've got them yet. Mr. Maddox, who were the two people for Zoom with the jail?
Kenneth Kane, Your Honor, and Michael Dillingham.
I've got other Zoom people. I'm just going to take those first, and then hopefully they'll be ready. Otherwise, we'll get to them.
Yes, Your Honor.
You are in the meeting.
Roger that. All right, good morning, everyone. Mr. Patel, you're here on the Sherry Meyer case, is that right?
Correct, Judge.
Okay. And have you had a chance to reach out to, I think it was the Assistant Attorney General that's new to the case?
Yes, her name's Jacqueline Hutchins. She's
Okay.
With us via Zoom now.
Okay, I didn't know if that was you or not, Ms. Hutchins, because I think I heard a different name last week that was slightly different. All right, so what are we going to do with Sherry Meyer? It's my understanding, Ms. Hutchins, you're relatively new to the case and trying to catch up to speed. I'm not quite sure, so that's why we're having the status conference.
Yes, Your Honor. I got this case on Friday officially. I realize that we are here for final pretrial, so I'll move to continue so that I can catch up.
Okay. All right, any objections to that, Mr. Patel? I'm assuming not based on prior. Go ahead.
That's correct, Judge. And I'll be working with Ms. Hutchins to get over, there's some discovery that's hard binders, so I'm gonna work with her to get her a copy of that to be able to inspect it, or do what we need to do to get going on the case.
Okay. All right, let's put it on 12/22 at 9 o'clock. Ms. Hutchins, you're based out of Tallahassee?
Your Honor, I'm based in Jacksonville,
Oh,
but
Jackson.
I can appear either via Zoom, or if you prefer, I appear in person, I can come to Pensacola.
If it's just status or something like this, obviously evidentiary hearings or getting ready for a trial, I'd certainly want you to be here. Otherwise, you're free to appear by Zoom. I'll mark it on my docket as Zoom, so I remember to turn it on when we get to December 22nd, but Mr. Patel, I'm sure will remind me.
Thank you so much.
All
Thank
right.
you, Judge. May I be excused?
Yes, thank you. Have a good day.
You too.
And may I be excused as well?
Yes. All right, I'm not sure why the pictures aren't showing up. I've got them all on my screen. All right, Mr. Johnson, are you here for Mr. Huggins? I'm sorry, that last case was Sherry Meyer, and I didn't give the case number 23CF2740. Mr. Johnson, you are here on the Huggins case, which is 24CF2652. I believe we're here as just kind of a status to see if the ICAC documents were available.
Your Honor, I did reach out to Sergeant King, and
I don't think you're on a microphone, Ms. Basso. Since he's on Zoom, I can hear you just fine, but I'm not sure if Mr. Johnson can.
Judge, I did speak to Sergeant King, and he did agree to provide them to the court for the court's review. So what we asked the court to do is Investigator Evans, who is the local ICAC individual, will provide those to you upon, he'll just make an appointment with you if that's okay, and he'll come by your chambers and bring them to you
Okay.
for in-camera review.
I have to contact my office
Sure.
and see if I have spare time to do that. Unfortunately, we're about to jump into the trial week, so I'm not sure how many I'm going to have. But I guess once we see what washes out on Friday and how much availability I'll have over the next 2 weeks, you can contact my office to set that up.
We'll do that, Your Honor.
All right. Any issue with that, Mr. Johnson?
No, Your Honor.
Okay. Let's
Thank
put
you.
this case on to 12/22 at 9 o'clock, pending the in-camera review of the ICAC guidelines.
Thank you, Your Honor.
And Judge, what is December 22? Is that like a pre-trial?
It's a pretrial conference, yes, sir.
All right, thank you.
All right, we'll see you on that day, Mr. Johnson.
Thank you, Judge.
Thank
Have a
you.
good day.
You too.
Thanks.
What I'm gonna do is restart the Zoom to see if I can get it to work right while we're waiting because they're not there. All right. Anybody else ready?
Please ready to go, Your Honor.
All right. Are they inmates or?
No, Your Honor.
All right, perfect. Call them up.
Mr. Brown? Mr. Fleming? Sorry about that, Your Honor.
That's all right.
Your Honor, this is Mr. Stefan Brown. I'm approaching with him now, Your Honor. We've reached a resolution in this case. Case number 24 CF 2752, Your Honor. In exchange for the plea today, I am withdrawing my motion to suppress in this case, Your Honor.
Okay.
May I
I've got notes
approach?
to that effect. Thank you, sir.
Yes, Your Honor.
All right, Mr. Brown, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Can you state your full name and date of birth, please?
Stefan Brown, 2/6/1980.
Okay, Mr. Brown, you're here in 24 CF 2752, where you're currently charged with possession of a controlled substance. It's a third-degree felony punishable by 5 years in state prison. Do you understand that? I've been handed a plea and sentencing agreement where the state's offered a lesser included offense of possession of drug paraphernalia. That's Florida Statute 893-147, paragraph 1, subparagraph A. Be an adjudication of guilt, 11 months, 29 days of probation, substance abuse evaluation, and any recommended treatment, $270 court costs, $100 cost of defense, and waive cost of supervision. Have you seen that agreement?
Yes, sir.
Is that what you want to do here today?
Yes, sir.
Have you gone over it with your lawyer?
Yes, sir.
And did you understand it and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation? Yes?
Yes, sir.
Okay, and are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for this plea?
No, sir.
To understand, by entering a plea of no contest, you're giving up your right to a trial and all your trial rights, which are on page 2 of the document you signed.
Yes, sir.
And you understand that if you're not a U.S. citizen, this could lead to your deportation.
Yes, sir.
And what is your plea to the possession of drug paraphernalia, first-degree
No
misdemeanor?
content.
I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty, 11 months, 29 days of probation, substance abuse evaluation, any recommended treatment, $270 court costs, $100 cost of defense, waive cost of supervision. I'll need you to speak with probation before you leave. I don't need your fingerprints, but I do need to advise you have 30 days to appeal.
Yes, sir.
All right, thank you, sir.
All right, thanks.
Bill Fleming?
And Mr. Brown's plea, as announced, is based on the fact of the motion to suppress, and that's not being pursued at this time, correct,
Correct,
Mr. Maddox? All right.
Your Honor, this is Mr. Fleming before the court in 25 CF 1724. Your Honor, we've reached a resolution if we may approach.
Yes. Thank you, sir.
Yes, sir. Keep your hands
The state's dismissing the felony driving while license suspended, and it's a plea to basically court costs for no motorcycle endorsement.
Yes, sir.
Yes, Your Honor.
Mr. Fleming, raise your right hand, please. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Bill Flynn, September 36th.
And Mr. Fleming, you're here in 25 CF 1724. You're currently charged with felony driving while license suspended, which is a third-degree felony punishable by up to 5 years in state prison, and also no motorcycle endorsement on your license, which is a second-degree misdemeanor, punishable by up to 60 days in county jail. Do you understand that? Do you understand that's what you're charged with?
Say it.
I need to hear you out loud so the microphone picks
Yes,
you.
sir.
Okay. I've been handed a plea and sentencing agreement that calls for you to plead to the no motorcycle endorsement. In return, it would be adjudication of guilt, time served, $300 in court costs, $100 cost of defense. I'd give you 180 days to pay that, otherwise there'll be a judgment. In return, the state has agreed to dismiss count one. Is that what you want to do today?
Yes, sir.
Mr. Fleming, are you familiar with the terms of this agreement that I've got in my hand?
Yes, sir.
Okay, then why are you looking at your attorney every time I ask you a question?
This,
I just listen to the questions. They're pretty simple, and I
Yes,
just
sir.
want you to answer without seeking advice
Yes,
of
sir.
counsel, other than if you've got a question where you need his advice. But things like yes or no questions or your name and date of birth shouldn't be things you need to look at your counsel for.
nah.
I just want to make sure you understand what you're doing here today.
Yes, sir.
Okay. All right. Have you read this agreement with your lawyer?
Best my knowledge, yes, sir.
He did, Your Honor.
Do you not remember going over the agreement, Mr. Fleming?
Yes, sir.
Okay, because you were here last week to do this and you left early, right?
Yes, sir, I will live, fell asleep at McDonald's. I live in,
Your Honor, he didn't want to disrespect the court. Your Honor, he was falling asleep, and that is why he left. He excused himself, so he meant no disrespect, but he did not want to fall asleep in court and disrespect the court, Your Honor.
I'm not taking it as disrespect. I just want to make sure that he understands what's going on here. And because last week he left before he entered his plea, that he actually has gone over this with you and understands it.
Yes, Your Honor.
All right, do you understand the agreement,
Yes,
Mr.
sir.
Fleming? And are you satisfied with your lawyer's advice?
yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced you to do this?
No, sir.
Has anyone promised you anything in return
No,
for your
sir.
plea?
No, sir.
And do you understand there won't be a trial if you take this plea?
Yes, sir.
Do you understand you're giving up your trial rights?
Yes, sir.
And those are on page 2 of the agreement you signed, right?
Yes, sir.
All right. And do you understand if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right, and what is your plea to the no motorcycle endorsement second-degree misdemeanor?
No time.
I'll accept your no contest plea. It's freely, voluntarily, knowingly given, adjudicate you guilty, time served, $300 in court costs, $100 cost of defense. You have 180 days to pay those, otherwise it'll go to a judgment, Mr. Fleming. I don't think I need your fingerprints. You don't need to talk to probation, so you have 30 days to appeal. Thank
Yes,
you.
sir.
Make sure you get those costs paid.
All right, good luck, sir.
I'm good.
All right,
Everything good?
everything's good. All right. Jacob Edwards. Your Honor, this is Mr. Jacob Edwards before the court in 25 CF 1611. Your Honor, we have a pretrial intervention agreement as part of a plea, if I may approach.
Yes. Thank you.
Yes, sir.
Yeah, there. So it's a plea to a misdemeanor?
Yes, Your
With PTI? All right, Mr. Edwards, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, can you state your full name and date of birth, please?
Jacob Aaron Edwards, September 30th, 2001.
All right. And Mr. Edwards, you're here initially on a charge of domestic battery by strangulation, which is a third-degree felony punishable by up to 5 years in state prison. Do you understand that?
Yes, sir.
And I've been handed a plea and sentencing agreement that would have you plea to a first-degree misdemeanor battery in return to do the pretrial intervention agreement that I also have a copy of here.
Yes, sir.
Have you gone all over both of these documents with your lawyer?
Yes, sir.
Did you understand them both?
Yes, sir.
All right, and did you sign the plea agreement?
Yes, sir.
And it looks like also you and the state attorney have signed the pretrial intervention agreement, correct?
Yes, sir.
Are you satisfied with your lawyer's advice and counsel?
I am.
Do you understand as part of the plea and sentencing agreement, if you fail to complete the pretrial intervention successfully, then you'd come back to court straight for sentencing?
Yes, sir.
You understand there wouldn't be a further trial at that point?
Yes, sir.
All right, and you understand that you're waiving your trial rights, which are on page 2 of the plea agreement that you signed?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
All right, and what is your plea to the misdemeanor battery, which is what, 784.03?
Yes, Your Honor, no contest.
No contest.
This is the state's agreement?
It is, Your Honor, after consulting with the victim per Mrs. Lawson.
All right, and as far as the terms of the agreement, it's batter's intervention program, no violent contact with the victim, Ms. Rogers, 622 in court costs, as well as standard conditions.
Yes, sir.
Any questions about that, Mr. Edwards?
No, sir.
All right, what I need you to do is talk to probation, since they're the ones that will handle the pretrial intervention agreement with you, and hopefully we don't see you back.
Thank you.
All right, thank you.
Tanisha Gadd?
I think they need the original copy back,
Yes,
if you can take that, Mr. Maddox. Okay.
Your Honor, Ms. Gadd is present and approaching. She's before the court in 24 CF 2791. Your Honor, we've reached a resolution in this matter to be a pretrial intervention agreement. Plea, Your Honor.
Okay.
Oh, hey, Ms. Gadd. May I approach?
Yes. All right, Ms. Gadd, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right. All right, can everybody keep it down a little bit? I'm hearing a lot of voices, and it's kind of hard to understand up here. All right, Ms. Gadd, can you state your full name and date of birth, please?
Tanisha Gadd, 21081.
All right, Ms. Gadd, you're here in 24 CF 2791, charged with a third-degree felony organized fraud charge. Do you understand that?
Yes.
All right, I've been handed a plea and sentencing agreement that calls for you to enter a plea of no contest to that charge, the organized fraud. In return, you're to do the pretrial intervention agreement, which means you'll complete this agreement, and when you do, your case will be dismissed. Otherwise, if you're not successful with it, you'll come back to be sentenced. Do you understand that?
Yes.
Did you go over these two agreements with your lawyer?
Yes.
Did you understand and sign them?
Yes.
Are you satisfied with your lawyer's advice and representation?
Yes, but I have a question.
Yes.
I have a disabled daughter. She's autistic, and I am homeschooling her, so I'm at home with her every day. And I was wondering,
I'm sorry, if you can just speak up a little bit. I'm going to see if I can turn up your microphone, but there's just a lot of ambient voices. I don't know why they seem to be worse today than normal.
okay, have an autistic daughter, and I homeschool her, and she's severe autistic.
Okay.
And I'm at home with her every day, and I'm just trying to see if I can get at least 60 days bumper before it starts, before the payment starts.
Before the payment starts. The problem is, I would guess, I didn't do the math yet, but usually the payments are based on equal installments over the course of the 24 months.
Yes, Your Honor, and it was structured to give her, as I do in all of them, a little bit of a buffer so that she doesn't violate for making the payments on time, so that's accounted for in there. But if we started in December, if she started paying in December, that shouldn't throw anything off. Because the state has no objection to that, and probation has no objection to that.
Haven't heard any. All right. All right, Ms. Gadd, are you under the influence of any alcohol, drugs, or controlled substances?
No,
Are you currently suffering from any mental health issues?
no,
Has anyone forced, pressure, or threatened you to do this?
no,
Has anyone promised you anything in return for your plea?
no,
And do you understand that by entering this plea, there won't be a trial?
yes,
And you understand that if you complete your pretrial intervention case, your agreement, that the case will be dismissed
yes,
upon proper payment of that money and everything else?
yes,
Okay. And do you understand that if you're unsuccessful, you come back and be sentenced? And you
yes,
could be sentenced up to the maximum of 5 years in prison or state probation. Do you understand that?
yes,
Not saying I would do one of those things or the other, just making sure you understand the maximums.
yes,
All right, do you know that you're giving up your trial rights, which are on page 2 of that agreement that you signed?
yes,
Do you understand that if you're not a U.S. citizen, this would ultimately lead to your deportation if you were to be unsuccessful?
yes.
Okay. And what is your plea to the organized fraud charge?
No, no contest.
I'm going to accept the no contest plea is freely, voluntarily, knowingly given. You're going to complete this pretrial intervention program, which I'm going to give you back the original copy. You need to talk to probation about it. And then I don't need your fingerprints today because it's not a conviction or anything today. But if you do come back on the pretrial intervention agreement, if it's unsuccessful, you could potentially be adjudicated guilty to be a convicted felon. Do you understand that?
Yes,
Okay. All right, Mr. Maddox, so if you could give that back to probation, you've got 30 days to appeal any judgment by the court. Ms. Gadd, talk to probation before you leave.
Court did announce that her payments would start December.
I'm fine with the payment starting in December. Okay. Go ahead and restart it. All right, Mr.
Di-
Maddox, if I could, apparently I've got the 2 inmates that we need for.
Yes, Your Honor, ready to go.
You are in the meeting now.
And then before we get that, or well, when Mr. K, actually, we'll see who we call first. Good morning.
Morning.
Who do y'all have first, Kane or Dillingham?
Kane.
Okay, perfect. May we approach briefly on this case, Your Honor?
Sure. All right, for the jail, I don't have any video, jail. All right, good morning, Mr. Kane. Can you hear me?
Yeah, I can hear you.
All right, Mr. Kane, I'm Judge Oberliesen. We're here on your competency evaluation. The parties have stipulated to the court making its decision on Dr. Zeman's report. Is that right?
Yes, Your Honor.
Okay. And I've reviewed your report, Mr. Kane. Based on the opinion and recommendation of Dr. Zeman, I'm going to find that you're not competent. I also find that you haven't showed any signs exhibiting a reason for involuntary hospitalization or restoration services. So I'm going to find that you're incompetent at this point, and reserve the issue as to whether or not he's going to go through any further restorative services.
Yes, Your Honor.
Yes, thank you.
Okay.
Would the court mind, I know we don't usually put him on this type of date, Your Honor, but is the jail able to bring him back on 11/7, November 7th, this Friday, if the court were to put him on that date?
For Zoom?
Yes.
Presume.
State's
After
gonna-
first
Yeah.
appearance, for sure.
Okay, then that's what I would propose, Your Honor.
Let's have a decision based on everything then. All right, Mr. Kane, we'll see you back quickly on Friday, the 7th, by Zoom, and hopefully your case will be completely resolved at that point. No, he's already gone.
This is Mr. Michael Dillingham, Your Honor, before the court in 25 CF 1362. We are here for a competency hearing, Your Honor. Does the court have the benefit of the report? Otherwise, I have a copy.
I don't have one in front of me, if you could give me a
Yes, Your
copy.
What is your name, sir? What is your name, sir?
I'm sorry,
What is
who,
your name,
This is Judge Oberliesen, sir. Hold on, he's reviewing your report, okay, like we discussed.
sir? Who we gonna discuss it, sir?
I discussed it
Who
with you.
discuss it, sir?
Hold on, let him review it.
thank you.
And I believe the state and I are stipulating to this report, Your Honor.
All right, so this is going to be Michael Dillingham, and the case number is 25 CF 1362. The state and defense stipulating to the court making its decision based solely on the one report from Dr. Zeman.
Yes,
Yes, Your Honor.
Okay. All right, Mr. Dillingham, I've reviewed your evaluation by Dr. Zeman. I'm going to find that you're not competent to proceed. And I am going to find that you're going to be sent to the Department of Children and Families for placement with the appropriate treatment facility so that you can get the treatment that you need.
All right, thank you, Your Honor.
Thank you. Make sure those are. All right. Thank you to the jail. Appreciate it.
I have one more ready to go, Your Honor. Take it.
Go ahead.
Darwin Dickerson. All right, this is Mr. Dickerson, President approaching before the court in 25 CF 909. I have here a pretrial intervention agreement and associated plea agreement, Your Honor, that my client has agreed to, if I may approach.
You say Dixon?
Dickerson, Your Honor.
Dickerson.
Yes, Your Honor.
Okay. There it
May I
is.
approach?
Yes. You have plea to a misdemeanor with PTI.
Yes, Your Honor.
All right. Mr. Dickerson, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth, please?
Dalen Saverine Dickerson, October 12, 2002.
Mr. Maddox, I'm missing your signature on that. All right, Mr. Dickerson, you're here in 25 CF 909, where you're charged with aggravated battery, which is a third-degree felony punishable by up to 5 years in state prison. Do you understand that?
Yes, Your Honor.
Okay. I've been handed a plea and sentencing agreement that would have you plead to a misdemeanor battery, 784.03, In return, you do a pretrial intervention program, which means if you do everything you're supposed to under the agreement, that your case would ultimately be dismissed. Do you understand that?
Your Honor.
However, if you don't complete the 11 months and 29 days of the PTI agreement, if you're unsuccessful or violate that in some way, you'll have to come back and you'll be directly sentenced.
Yes, Your Honor.
And do you understand that you can get sentenced to anywhere up to 11 months, 29 days in probation or jail?
Yes, Your Honor.
Okay, is that what you want to do today?
Yes, Your Honor.
All right, and did you go over these two agreements with your lawyer?
Yes, Your Honor.
Did you understand them both?
Yes, Your Honor.
Are you satisfied with your lawyer's advice?
Yes, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Are you suffering from any mental health issues?
No, Your Honor.
Anyone force, pressure, or threaten you in any way to enter this plea?
No, Your Honor.
Anyone promise you anything in return for your plea?
No, Your Honor.
You understand there won't be a trial of any kind?
Yes, Your
You
Honor.
understand you're giving up your trial rights?
Yes, Your Honor.
You understand that even if you come back unsuccessfully, you won't be going to trial then and be directly to a sentencing hearing?
Yes, Your Honor.
All right, and do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, Your Honor.
All right, and the terms of the agreement are the standard terms plus successfully complete batter's intervention program, also complete a substance abuse evaluation and any recommended treatment, or in substitute of that, it says complete, but comply with the ECLC program.
Yes, Your Honor. Sorry about that.
It's okay. I just know that's the language they like. Also, 24 hours of community service at court-approved locations. Hours may be bought out through a donation to a domestic violence charity at the court-approved hourly rate. And then 622 costs, $100 appointed counsel fee. And then you got to supply the proof of those completions to your probation officer. Do you understand all that?
Yes, Your Honor.
All right, and what is your plea?
No contest.
I accept your no contest plea is freely, voluntarily, knowingly given. I'm going to give you back the original PTI agreement. I'm going to require you to do the PTI agreement. And again, if you fail, you'll come back for a sentencing where you could get as much as a year in jail. All right, talk to probation. You have 30 days to appeal.
Thank you, Your Honor. And I got a couple other clients to talk to. That's all I have ready to go.
Okay, Mr. Catalinick, you look ready.
I appreciate it, Your Honor. Your Honor, I have two cases on the docket. The first one that I'd like to call, Your Honor, is Holly Nicole Mason, 24 CF 2413.
Here it is. All right, go ahead.
Your Honor, it's going to be a plea. Do you want me to just give you the plea and you read it?
Yeah, I'll handle it from there. No sense of,
Somebody else, so it's nice.
I appreciate it, Mr. Catalinick. I give him a little grief about his handwriting sometimes. All right. When is the 10 days jail going to happen? Is that?
I'm sorry?
10 days jail that's listed here. When does
Yes,
that,
sir.
does that start today?
No, Your Honor, we're asking, it says weekends on it, and she lives out of state.
Oh, there it is, the last part.
Yes, sir, I apologize.
Oh, no, it's fine. I just missed it, the last sentence, because it's farther away from the jail time. So when is that going to be scheduled?
Yes, because I do have twins.
So it would have to be consecutive weekends until they're done.
Consecutive weekends.
What does that mean?
Every 2, 4, 6, 8, and one more would be 9, because you got credit for consecutively. In other words, you can't skip weekends. You have
Okay.
to do them straight.
Every weekend
I
until
got
they're
you.
done.
Okay. So what, does that fall on Thanksgiving?
I'm sorry,
Does
speak
that
up.
fall on a holiday or anything? I'm just trying to figure out, because I have twins that are 2 years old and they're,
It has to be consecutive.
okay.
Okay?
So that's 1, 2, 3, 4. Okay, that's fine.
We have that start on the 14th. I think that's a Friday.
Okay, so that would be next Friday.
Yes, sir.
All right, Ms. Mason, so it would start next Friday. You report in by 5 o'clock at the county jail here in Crestview, 5 p.m., sorry. You'll basically serve 48 hours, be released on Sundays at 5 p.m. You'll do that consecutive weekends until you finished your 10 days.
Okay.
All right. All right, Ms. Mason, you can raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Ms. Mason, you're here in 24 CF 2413, where you're charged with felony petty theft, a third-degree felony punishable by up to 5 years in prison. Do you understand that?
Yes, sir.
All right, I have a plea and sentencing agreement that calls for you to plead no contest to that charge. In return, you be adjudicated guilty. 2 years of probation, 10 days in the county jail what did I say?
I think you said 3, Judge.
Did I say 3?
I think you did.
I heard 2. I said 2.
Sorry.
It's okay. I don't have a problem with you correcting me if I'm actually wrong.
I apologize.
No, I do those things. I say April instead of August or whatever. I do it quite frequently. I always tell people, make sure you correct me, because I want to make sure the record's clear, even though we all understand what I meant to say. The record is what I actually said. All right, thank you, Mr. Katalinik. All right, so it'll be 2 years probation, 10 days in county jail to be served on weekends starting November 14th at 5 p.m. It'll be each Friday, 5 p.m. to Sunday at 5 p.m. until you finish. You'll do a shoplifters awareness course, 515 court costs. What do we do with restitution? Do y'all know the amount? Restitution? Do y'all have an
90
amount?
days, Your Honor.
How many?
90?
90
days
days
for
to
the-
determine restitution?
Yes, sir.
And credit for time served. I think that seems to be everything.
Yes, sir.
All right, Ms. Mason, have you gone over this plea and sentencing agreement with your lawyer?
Yes, sir.
And did you understand it?
Yes, sir.
And is that what you want to do today?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
And are you satisfied with your lawyer's advice?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Do you understand by entering a plea of no contest, you're giving up your right to a trial?
Yes, sir.
And all of your trial rights, which are on page 1 of the agreement that you signed?
Yes, sir.
And you understand that you're waiving all potential defenses?
Yes, sir.
Has anyone forced you to do this? Anyone promised you anything other than what we've discussed here this morning as
Yes,
far
sir.
as your plea?
Yes, sir.
And do you understand if you're not a U.S. citizen, you could be deported because of this? All right, and you understand this is an adjudication of guilt, which is a felony conviction?
Yes, sir.
Okay, and what is your plea to the felony petty theft?
No contest.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty, 2 years of probation, 10 days county jail to be served starting November 14th on weekends. That'll be 5 o'clock p.m. Friday to Sundays at 5 o'clock until they're completed. Credit for time served, shoplifters awareness course, 515 court costs, 90 days to determine restitution.
Okay.
Anything that I've missed? All right, I need you to speak to probation and be fingerprinted or reversed. All right, fingerprinted first, then talk to probation. They do the opposite for inmates, so sometimes I forget which one's which. All right, and then you have 30 days to appeal the sentence. And this is a guideline sentence. She scored 14.6 points.
Correct.
All right, thank you, Ms. Mason.
Your Honor, I have
All
one
right.
more case.
Go ahead.
Stephen Harrell. Your Honor. He's
Okay.
not here. May I approach?
Yes, who's on Harrell? All right, for Stephen Harrell, I'm going to issue a capias without bond. However, like I said, Mr. Catalinic, if you get him here on Friday and he takes the plea, then we can do that as well.
Thank you, Judge. That's all I have, sir.
All right, thanks. Have a good day. Mr. Williams?
Good morning, Your Honor.
Morning.
Mr. Williams. Your Honor, the first case I have with you is State of Florida versus Tyshawn Morris. There's four case numbers, 22 CF 1436, 23 CF 2394, 25 CF 1174, and 25 CF 1175. Your Honor, you appointed me to represent Mr. Morris last Wednesday. So it's the first time up. I haven't really had a chance to go to the jail and meet with him.
I think the situation was, Mr. Williams, I put him on for Thursday, thinking you were going to be here for your other case, which we then had to move to today. So I just was trying to get his cases moving by have you introduce yourself to him and talk to him if y'all had a chance.
We'll do that, Your Honor. I'll be out to see you at the jail real soon.
Okay.
Yes, sir.
So what I'm going to do, Mr. Morris, I'm going to put your cases on December 23rd at 9 o'clock. Mr. Williams will come out and talk to you about all of them sometime shortly, and then we'll see where we're at that point.
Sir. See you soon.
All right, thank you, Mr. Morris.
Your Honor, next I have State of Florida versus William Talbot. That's 22 CF 2507. Your Honor, we thought we had completed
We all made a
this
mistake
case.
last week, right, or 2
Yeah,
weeks ago? whatever.
we left off on the plea and sentencing agreement. We left off count 4.
And which case number?
That is 22 CF 2507. And I believe that the state has an announcement with regard to that count that would wrap this up.
Your Honor,
Let's
the
just make
state-
sure we're clear. On 2022 CF 2507, a plea was offered and given back in August, actually, where he pled to 60 months in Department of Corrections. But for some reason, count 4 was left off of the plea agreement. So we're just addressing that today.
That's
Yes,
correct,
Your
Your
Honor. And the state would be willing to just dismiss the account,
Okay.
make it, with the understanding that that does not change the sentence agreed upon.
All right. So count 4 will be dismissed by the state. But everything else is the same based on the plea agreement that was already accepted back on August 27th.
That's correct, Your Honor.
You understand that, Mr. Talbot? Nothing's really changed other than just cleaning up the plea agreement to make sure all counts were resolved.
So Yes, sir. Yes, sir. I think he's pleased, Your Honor.
All right. Thank you, Mr. Talbot.
And Your Honor, that concludes my business today.
Okay.
Sorry I was a little late. I had a couple of hearings with Judge
I don't get
Collins.
anybody for being late as long as they're here when it's time to call their cases. So, all right. Thank you, Mr. Williams.
See you later.
All right. Is anybody else ready? Lines?
Yeah, I can call my out of custody people. Yeah, I just sent it.
Yeah, I said yeah.
Gabriel Augustine. And he will be followed by Marcus Timmons. This is Mr. Augustine, Your Honor. I know, I hate to say it again, but Mr. Augustine, if we could approach briefly.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m.
All right, Mr. Augustine, we're going to have you come back on Friday. That's November 7th. Make sure you finish your appointment up this afternoon, as your attorneys advised me, because the state's offer is going to be based on that. Make sure you're here Friday, 9 o'clock, 11/7.
Yes, Your Honor.
All right, man. Call me this week. Okay. Your Honor, next I have Marcus Dimmons to be followed by Tony Henderson. Your Honor, this is Mr. Dimmons. This is his first time up with me. I did receive this morning an offer to resolve this situation with Mr. Dimmons and with Mr. Kimmons. However, I don't have the discovery in those cases, so I don't really have anything I can compare the offer to see whether it's a good offer. I would just ask the court to continue this one cycle for Mr. Dimmons. I do have the plea offer in hand now, so once I get the discovery, if we get an early resolution or something, we'll advance it on an earlier docket.
Yes.
Mr. Dimmons, we're going to see you back on December 22nd. Make sure you're here on that court date. Stay in touch with your lawyer so he can go over that offer and discovery with you.
I'll call you when I get the discovery.
12/22 at 9 o'clock.
Next in the gallery, I have Tony Henderson to be followed by William Kimmons. This is Miss Henderson. Your Honor, in reviewing the body camera footage, there's some search issues that have popped up. I've talked with Miss Leone. We're going to ask to continue this one cycle. We'll get those depositions set in anticipation of a motion hearing.
No objection.
All right, Ms. Henderson, it's going to be December 22nd at 9 a.m. for your next pretrial conference. Stay in touch with Mr. Kleins, and we'll see you back on that date.
Yes, sir, thank you.
Call my office, okay? Next, I have William Kimmons. Your Honor, Mr. Kimmons is pretty much in the same situation as Mr. Dimmons. Offers are in hand. I do need to review the discovery and talk about this with Mr. Kimmons, so I would ask support for one cycle continuance.
No objection.
All right, Mr. Kimmons, we'll see you also back on 12/22 at 9 o'clock. Stay in touch with Mr. Kleins.
Sir. All right, cool. Yes, sir. Next on the docket, Your Honor, is Haley Riggs. I believe the state filed a no pros on that on
We
Friday.
did, Your Honor. I believe it was done Friday, so it may not have made it to the docket yet.
May not have.
We did file it, and I received we sent a courtesy copy to Mr. Kleins' office.
Okay. So that's 25 CF 515. State is announcing a null pros and has already filed a written one.
Yes, sir.
All right, thank you.
Next, I have Jenna Rogers. Ms. Rogers is present and approaching. Your Honor, we're going to have to ask to continue this one cycle. We had left this on for today, and kind of optimistic hopes that maybe we might get some early movement, but this case is pretty much brand new. This is the first time she's on the docket. So if we could ask to continue this to the 12/22 date.
So without objection, Your Honor, I did give Mr. Klein some information you can share with this client, and I believe he has some reciprocal for me.
Okay. Yeah, I think it's the first time up, or it was last week.
Yes, sir.
12/22 at 9 o'clock is your next court date. Ms. Rogers, stay in touch with Mr. Kleins.
Yes, sir.
Thank you.
And last I have out of custody is Ashley Woody. Ms. Woody is present and approaching. Your Honor, we have taken the depositions in this case. We don't have any motions we need to be filing. I did talk with Ms. Woody. She does want me to announce plea or trial, 24 CF 2724. I did explain to Ms. Woody that the court's practice is not to accept negotiated pleas after today, that she can expect the state to withdraw any existing plea offers, but I don't want to just continue this because the case is ready to be disposed of.
I don't think it was set for trial last.
It was, she wasn't here. So
I don't think you get to miss court, then come in at docket
Well,
day and say, I'd like my trial now.
I want the court to be aware that we're ready for trial. If the case has to be continued, I'll certainly defer to the trial docket as it exists. And I did explain to her
You
that.
showed up pretty late, right?
This morning?
No, last week.
Yes, sir. I
And it was
did.
after Mr. Klein's was already gone.
Yes, sir, it
So I
was.
set it for today so we
Yes,
could
sir.
hopefully get something done. But I can't set it for trial because the state has not sent out their
fine.
subpoenas, so they won't be able to do that
Fair
fast
enough.
enough.
But it will be set for trial next cycle then.
Any issues with that, Ms. Leone?
Oh, no, Your Honor.
All right. 12:22 at 9 o'clock will be your next pretrial. Make sure you're here and on time, Ms. Woody, so we can set your case for trial, because if you don't show up, I can't set it.
Yes, sir. I will be here. Thank you so much.
Your Honor, I have one in custody that I can dispose of now, and I have another one I need to pass. Do you want me to just pass it over to the PD so they can continue working on the crowd, or?
You have anyone lined up? Okay.
That's fine. I'll defer.
We'll take it.
Yes, sir.
Once everyone's ready. Mr. Nopes?
Your Honor, I've got, the first case I've got is Stephen
Sounds
Barber.
like you've got a cold.
I'm going to urgent care when I get out of here. I've got two grandbabies. They're 3 or 2.5 and 8 or 7. So I'm sure it started at Walker Elementary School and it's worked its way to me. 25 CF 880. Mr. Barber is present, Judge.
Stephen Barber?
Judge, I just asked to put this on 12/22. We had an issue that come up when he met with me last week, and I want him to make a phone call to somebody in Tampa that does some of these sexual registration cases to see if he might qualify to be removed. And I don't know the answer to that, but before we enter a plea.
I want to verify he should actually be on the list.
Right, exactly.
Like an out-of-state conviction or something like that?
Yes, sir.
That seems to be the biggest issue that comes up.
But I don't know the answer to it, so I just want to put it off till December 22nd, and in the meantime, he'll speak with this person and see where we're at.
Who's the state attorney on that?
I am, Judge.
All right, any issue with that?
No objection.
All right, Mr. Barber, I'm going to give you December 22nd at 9 o'clock for your next pretrial. Make sure you handle the business that Mr. Nopes is talking about so that we can make some progress next week. I don't expect I'll continue it again for that reason.
Understand, Judge.
All right, thank you, Mr. Barber. We'll see you back on that day.
Bye later, okay. Judge, the next case is in custody, but I want to pass him because I want to talk with the state. Mr. Dandridge, I want to speak to the state before I cover him.
We'll pass it for now.
And Bradley, last name's Giese. Judge, I did chat with him last week. We had taken depositions and.
Mr. Geis here? If you're here, come up when your case is called.
Judge, the case had been being handled by Josh Sick, and he was checking on a couple of things that had come up during the deposition, and then I didn't hear back from him, and then the next thing I know, how long was he gone?
I can only tell you what I've been told, and it's changed at least once, so.
Okay, well, I'd just like to pass it until he gets back so we can.
We have an idea when that is, or is that ever changing?
I don't know, Your Honor.
Well, at some point, we're going to have to make some decisions on cases if we don't know when Mr. Sheik is going to be back from his service.
You know, I'd be more than happy to help out if he can share with me what the discussion was. I don't have any notes in the file, so I cannot say anything.
I'll I'll throw you an email, and then maybe can come and sit down and speak with you about it.
Sounds good.
All right, Mr. Geis, we'll see you back on 12/22 at 9 o'clock. Stay in touch with Mr. Knowles.
Good to go. Judge, the next case I've got is Joseph Lolly, 24 CF 1610.
I'm sorry, Mr., what did you say? I didn't hear you. Oh, as charged? Okay, that's fine. I'll get the score sheet in a second.
Your Honor, he's entering a plea as charged to the burglary of an unoccupied dwelling. It is a second-degree felony. He's also entering a plea to grand theft. Approach with a score sheet, Your Honor.
All right, I'm reading through the agreement. Why is it early termination at 19.2 months if all requirements are completed?
She had indicated she wanted him to do 80% of the probation. That's 80% of 24 months.
If he completes all the requirements and no violations, of course.
I understand. Just wanted to make sure I understood that. All right, were you appointed in this case, Mr. Knowles?
I was, Your Honor.
Okay. All right, Mr. Lally, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, can you state your full name and date of birth, please?
Joseph Michael Lally.
Can you pull the microphone a little closer to you? I can hear you, but I don't think the record might be picking you up. All right, Mr. Lally, you're here in 24 CF 1610, where you're charged with burglary of an unoccupied dwelling, second-degree felony, punishable by up to 15 years in state prison, as well as grand theft from a dwelling, which is a third-degree felony, 5 years state prison maximum. Do you understand that?
I do.
All right. I'm showing that he scored 57.8 points, so that's 22.35 months. Is this a downward departure then?
Yes, due to the need for restitution and uncoerced plea agreement.
All right, Mr. Lally, have you gone over this plea and sentencing agreement?
I have.
Did you understand the terms of it? And did you sign it?
I did.
Okay. There it is. All right. And are you satisfied with your lawyer's advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues?
No.
You understand by entering a plea, which is the 2 years of probation with potential early term, as well as restitution, no contact, anti-theft device, and some costs. You enter that plea, there won't be a trial?
It's a class, not a device, right?
Oh, did I say device? Anti-theft class and the ECLC program?
Right.
All right, sorry about that.
Yeah.
I'm fine to be corrected. You understand there won't be a trial then? And you understand you're giving up your trial rights, which are on page 2 of the agreement you signed? And has anyone forced, pressured, or threatened you in any way to enter this plea?
They have not.
Has anyone promised you anything in return for your plea? Do you understand you're waiving all potential defenses by entering a plea?
I do.
And you understand if it's a withhold of adjudication, so it's not a felony conviction?
I do.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Sure.
And what is your plea to the burglary of an unoccupied dwelling and grand theft?
It's no contest.
I'm going to accept your no contest plea as freely, voluntarily, knowingly given. Withhold adjudication, 2 years probation, possible early termination at 19.2 months if all requirements are completed and there's been no violations. No contact with the victim, Richard Perry. His address is listed here. Restitution is going to be $1,510 to Mr. Perry, $515 court costs, $150 court-appointed legal assistance fee. They're going to complete an anti-theft class and comply with the ECLC program. Minimum of $100 a month towards the restitution. And I'll waive cost of supervision due to the fact that you're represented by public counsel. Anything that I've missed? All right. It is a downward departure based on the two reasons announced. The need for restitution outweighs that for prison, as well as an uncoerced plea agreement. I'll need you to speak to probation, and then you've got 30 days to appeal.
Judge, the next case I've got is Terrence Parker, but I also need to speak with the state, so.
Okay.
Just
You wanna
pass
skip
both
him
of those.
then? You want to pass him?
Yes, please.
Got Mr. Tony, I've got Mr. Powell.
I'm ready, Judge. Come on, Mr.
All right. Go ahead, Mr. Tony.
My first matter is State of Florida versus Amber Lynn McGovern, and that's 2025 CF 1014. Your Honor, we've entered into a pretrial intervention agreement on that,
Okay.
but I didn't know if the court needed a written agreement as well.
Is it a plea or just PTI?
It's-
Plea into PTI, the plea is to a misdemeanor battery.
Okay. So I need the plea agreement that shows that it's a misdemeanor battery and then the PTI, sure. Otherwise, it gets confusing. I appreciate it, Mr. Tony. That makes it easier for me. What is that? Oh, that's the, okay. All right, Ms. McGovern, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your full name and date of birth, please?
Amber Lynn Lee McGovern, October 3rd, 1999.
All right, and Ms. McGovern, wait. Okay. A little bit of a typo here, I'll fix. All right, Ms. McGovern, you're here in 25 CF 1014, where you're currently charged with aggravated battery, which is a second-degree felony punished by up to 15 years in state prison. Do you understand that?
Yes, sir.
You can put your hand down.
Okay.
Thank you. All right, I have a plea and sentencing agreement that would have you plead no contest to a misdemeanor battery, which is 784.03, with the conditions that you would complete the pretrial intervention program. If you complete that program, then your plea would be withdrawn and the case dismissed. If you're unsuccessful at that program, there wouldn't be a trial of any kind, and you'd come back for sentencing. Do you understand that?
Yes, sir.
All right. Have you gone over the plea agreement with your lawyer?
Yes, sir.
Have you gone over the pretrial and intervention agreement with your lawyer?
Yes, sir.
Did you understand them both?
Yes, sir.
And did you? It looks like you signed both. Is that correct? All right, are you satisfied with your lawyer's advice?
Yes, sir.
And are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? And has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything in return for your plea?
No.
Do you understand if you plead, there won't be a trial of any kind? And do you understand that you're waiving all of your trial rights, which are on page 1 of the agreement that you signed? And do you understand if you're not a U.S. citizen, this could lead to your deportation?
Yes.
Do you understand that the pretrial intervention agreement is for 12 months?
Yes.
And do you understand that you're required, in addition to the standard conditions of a pretrial intervention agreement, you're to have no violent contact with the victim, you're to complete a batterers intervention program, complete 50 hours of community service, or can buy them out by making a donation to a domestic violence nonprofit organization. You're also going to complete a mental health evaluation, treatment, or comply with the ECLC program. Do you understand all that?
Yes.
And what is your plea to the misdemeanor battery?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. It's going to be a plea to the pretrial intervention program, which I've already announced. Looks like $515 in court costs, which you don't see on the agreement. And then I'd like you to do the intervention, batter's intervention within the 60 days, get signed up and started with that. Yes?
Okay, yes.
Okay. I need you to talk to probation, and you have 30 days to appeal any judgment of the court, but they'll explain to you how you're going to do your intervention program.
Next, Your Honor, I have State of Florida versus Donald Stewart Hinton, 2025 CF 1283. Come on up here, Bama. Your Honor, in this case, we've talked to the state, and they're not going to object to Mr. Henning being interviewed for the Veterans Court. We just need to take care of that.
Has he talked to anyone from vet court yet?
No, well, Your Honor, we just agreed to it yesterday, so.
Okay, no problem, I'm just asking. All right, I just want to know if I'm giving you a new court date or if he's going to go over to drug court. Probably need a control date here at least. So, Mr. Hinton, I'm going to give you a date here of December 22nd at 9 o'clock for a pretrial conference. Obviously, if you meet with Veterans Court and you plead into that program, you wouldn't have to come to back to this court date if your case is resolved there.
That's all I have, Judge.
All right, thank you, Mr. Hinton.
Thank you, Your Honor.
Mr. Powell? Morning.
This first matter I have is Robert Kletzker. We have a negotiated plea agreement to a misdemeanor. I have a written plea agreement with fingerprints attached. If I could approach.
Yes. Thank you. All right. Mr. Powell, when's he going to report to probation?
Judge would just ask for a couple of days. I mean, he's today, whatever.
It has to be the same day, because if he's not instructed on his probation and he does something that's in violation of it, it basically doesn't count. So he needs to meet with probation today.
Would that be JCS or state probation?
I don't see anything saying it's going to be JCS, so it would certainly default to DOC. Can he do that today?
Yes, sir. He's
If what?
he's able to phone in.
You say phone in?
Well, he lives out of state, so that was the issue we were trying to finagle, and he does have some pretty substantial health.
Okay. What I'd like to have you do, Mr. Powell, is just talk to probation real quick to make sure that everything works out, because these plea to a misdemeanor, but it's DOC. Sometimes it doesn't quite work well, especially depending on what state it is. So I just don't want to put him in a situation where I'm setting him up to fail by it not working properly. And it turns out he's going to have to come here to check in, and then maybe he can't go back home right away. Sounds, go ahead.
Sorry.
It's all right.
It might be easier for him to report to JCS.
I understand that, but that's something y'all have to talk about and agree to, and make sure someone's talking to JCS, because I don't really deal with them. Right. I don't know how they work those things. I would think you're right on that, but I don't want to make any representations that that's going to work better in some way, but.
I don't believe the state has an objection to that, and I know they have a QR code that they could apply right remotely through phone, and then the way it works with JCS is they get in contact within a couple of days after he fills out that intake.
Again, if he's put on probation and isn't given instructions, then it's like he's not on probation, and the clock doesn't start running. So if y'all want to clear it up with JCS and have him report the way they want today, I'll do it. Otherwise, I don't want this to be in a situation where suddenly he's getting violated for not calling them within the first few days. But he's going to say, oh, I didn't know I was supposed to do that, because the paperwork that he signed and went over doesn't say that.
Thank you.
Let's just make sure it's clear before we do anything that's going to cause a problem.
Understood.
I'll give it back to you. I'll take it later today, but I just need the proof that he's done that.
And Judge,
Well, I understand, but the things have changed since you've talked to him. So if he's not instructed on it and the paperwork he signed doesn't say to do that, then he's not going to know any different.
I'll discuss.
And frankly, I've got concerns with that being the situation where he's pleading to a misdemeanor, which probably isn't going to be something they would extradite him for, and then he doesn't even get instructions on how to report because he's from across the country. So let's just clear it up, and then I'll take it once you do.
Thank you, Judge. If I can pass other cases for just a moment.
That's fine. Did I not give it back to you? Do you have McGovern? All right. Anybody else ready?
Judge, I can call.
Are they out of custody if we can get people
Yes,
out of
Judge,
here?
I can call out of custody. Let's see, Isaac Calvo. Come get on
Mr.
this side,
Calvo,
Mr. Calvo.
and keep your hands out of your.
Oh, sorry.
I know it's a nervous thing. I do it all the time too, but.
Judge, actually, let me pass Mr. Calvo. He says he's got a question for me.
Okay.
Might be too
We'll
late.
bring you back up, Mr. President.
Okay. George Hastings Davis.
Is it under Hastings or Davis?
It's under Davis, Judge. His middle name is Hastings.
Okay. I got it. Go ahead.
Judge, I'm going to, I thought we were going to be entering a plea this morning. I spoke
So
with
did
Mr., it was set plea or continuance. I spoke with Mr. Davis. He'd like me to pass the case out so that he can come in and talk with me again. Apparently, there's some questions I need to answer. It sounds like predominantly from his family.
All right, State.
Your Honor, that's without objection. Mr. Williams did mention that to me. The offer remains open.
All right, Mr. Davis, we'll see you back on December 22nd at 1 o'clock p.m. Stay in touch with Mr. Williams. If y'all get those questions answered and want to bring it in earlier, you certainly can, Mr. Williams.
Thank you, Judge. Okay. Henry Leto. Judge, this is Henry Leto, 4625 CF 945. It's a negotiated plea.
All right, Mr. Henry, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Etar Henry, 12/18/74.
You said Leto R. Henry.
Yes, sir.
Okay, I got you. Just wanted to make sure I heard you right. All right, you're here in 25 CF 945, where you're charged with failure to report a change in address, third-degree felony, punishable by up to 5 years in prison. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that would call you for you to plead as charged, adjudication of guilt, 6 months community control, followed by 12 months of probation with a GPS monitor at $1 per day throughout your entire supervision. So that's 18 months of supervision with a GPS monitor. $515 court costs, $150 in PD fees, cost of supervision waived. Do you understand that agreement?
Sir.
Is that what you want to do here today?
Yes, sir.
Is that the state's agreement?
It is, Judge.
Okay, and it's a downward departure, and the reasons for that?
It's a negotiated plea. We would note that Mr. Henry doesn't have any failure to register priors, and he has had no criminal history in recent years.
All right, Mr. Henry, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
And did you sign it?
Yes, sir.
Okay. And are you satisfied with your lawyer's representation and
Yes, sir.
counsel? Yes? All right. And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to do this?
No, sir.
Anyone promised you anything in return for your plea?
No, sir.
All right. By entering a plea of no contest, do you understand that there won't be a trial and you're giving up your trial rights, which are in the agreement that you signed?
Yes, sir.
They're starting on page 1 and go on to the second page. You've
Yes,
read
sir.
those? Okay. And do you understand you're waiving all potential defenses that you have?
Yes, sir.
And do you understand that you are, if you're not a U.S. citizen, you could be deported because of this?
Yes, sir.
All right. And what is your plea to the failure to register a change in address?
No contest.
I'm going to accept your plea as freely, voluntarily, knowingly given. Adjudicate you guilty, 6 months of community control, followed by 12 months of probation with a GPS monitor throughout all 18 months of that supervision. It's going to be a GPS monitor at the lowest permissible, which is $1 per day. $515 court costs, $150 PD fee, cost of supervision waived due to the fact that you're represented by the Public Defender's Office. And this is a downward departure due to the fact that it's an uncoerced plea bargain and the reasons stated by the state attorney on the record. All right, Mr. Henry, I'm going to need your fingerprints, and then you have to talk to probation before you leave. Fingerprints first.
Yes, sir.
And then you have 30, say again. Oh, costs are $666 on this charge. Does that change anything you want to do, Mr. Henry? No. Okay. Yeah, I understand. I just have to make sure it's right. All right, you have 30 days to appeal as well. All right. Next case, Mr. Williams.
Jeffrey Johnson. Judge, Mr. Johnson's here because he missed court on Wednesday. And
Did.
excuse me, last Monday. Not Wednesday. He stands before the court. I had planned to continue his case.
Is there a reason why it wasn't here last week?
It was I just read my bond information wrong. I thought it was on the 30th. I didn't mean any disrespect at all.
Did you show up on the 30th?
I talked to him before then.
Okay. All right, well, just so you understand, I take notes of all these things, so if we
Yes,
have
sir.
that kind of mix-up again, I may not believe it as much.
Yeah, I'm sorry about that, sir.
All right. It's a due case. I'm going to put it on December 22nd at 1 o'clock. You got that date?
Yes, sir, I got it.
Okay, December 22nd, 1 o'clock. Stay in touch with Mr. Williams, and we'll see you back on that date.
Thank you, sir.
All right.
Thank you, Judge.
Thank you.
Chris Krivick. Chris Krivick.
Krivick.
Judge, Mr. Krivick is normally in court. I did speak with a witness that he had given me after a couple of attempts. I was able to reach her yesterday and was going to, even though it was set for trial, based on talking with her, amend reciprocal discovery to add her as a witness and move for a continuance. I don't know why he's not here. I haven't spoken with him since I spoke with her. He may be.
Want to check?
Judge, this is Mr. Krivick approaching now. Judge, since Mr. Krivik's now present, as I'd indicated, I was able to reach this Linda Van Dyke. We're amending reciprocal on it. It looks like she's got some information that verifies some of what Mr. Krivik had previously told me, and it's somebody I'll be calling.
Well, obviously, the state objects, Your Honor. I've never heard of this other person. Additionally, I can mention to the court that he was not present on the day of the incident. The defendant made statements about knowledge and possession of the trafficking amount of drugs. They were in the defendant's pants. So,
Judge, I think I can proffer at least some of what she told me. The individual the state's listed as the driver of the vehicle, that's not actually that individual's name. The individual's name is Ben. I don't have my notes on the conversation right in front of me, but Ben somebody. She also confirmed that Mr. Krivik was wearing boxer shorts when he left, not pants. That's been one of the issues. The vehicle.
This is the "these aren't my pants" defense.
yes.
The vehicle is her vehicle. The keys are actually hers, but Mr. Krivik was the individual that was authorized to have it. And so what she's telling me is dovetailing with Mr. Krivik's statement that when he said that the keys were his, he was referring to the keys for the vehicle.
That's not the evidence.
And why was this not disclosed until now, when this case is from July of last year?
Because she didn't, well, and partially because I didn't learn about her until, if it wasn't within the last docket, it was right before, when he came in to visit me right before. She didn't
Before the
respond.
last docket, like August?
Yes, sir. I don't have my notes in front of me, so I'm not certain. I do know that when I tried to call her, I was never able to get a hold of her or leave a message for her. I decided to try again yesterday, in between the time seeing people out at the jail yesterday, and just managed to get a hold of her.
Your Honor, I can only say that I'll file a motion once he shares formally in amended discovery. He hasn't done, I haven't seen it yet, then I'll file a motion, and if we can, and I guess a notice of hearing for Friday.
Go ahead, Mr. Williams.
In limine against you introducing this person that I never heard
As
of.
opposed to taking her deposition.
Between now and trial? I
Yes.
don't have,
Well, or I'll take the hit on the continuance if you'd like. But,
you already continued it a few times, so.
all right, Judge.
Have you put it on a amended or a reciprocal discovery?
Judge, again, she didn't speak to me until yesterday afternoon. My secretary was not available to do that for me. I don't know, I haven't checked my pending to see if there's one in there yet.
I probably would continue it based on that, as it hasn't actually been done. So there had, I'm not, I don't have an official witness listed that to continue the case at this point.
If you want to pass it, I can try to do it myself.
I just want to make sure all the things are done in the proper order, because you're asking about a witness who you haven't listed officially up to this point, so they can't even really object to it, like she said, until you list them. And so continuing a case when this is not a ripe issue yet, I mean, I think ultimately the case law is going to tell me that I have to continue it because it's a lesser problem than going forward and have it potentially come back on appeal based on a witness issue. I mean, the case is old. It's certainly far from the oldest I've seen. And I know there's a substantial prison guideline sentence. So out of an abundance of caution, I think I would have to give it continuance once those things actually happen. My concern, Mr. Williams, if I do it this way, then all someone has to do is say there's another witness and we get every case continued without it actually being put on the official record. I'm not blaming you for this, Mr. Williams, at all.
Again, Judge, I can try to do it myself here in court.
Well, I understand. I just want to make sure that all the ducks are in the proper row.
Yes, sir.
All right. So until something else gets filed, I'm going to leave it on for 11/7 for trial with the understanding of what the court's already told you as far as how it's going to have to be handled. But I certainly don't appreciate cases being continued at the last minute due to witness issues because they just don't show up or they're not even told, that people don't tell their lawyers about it until over a year into it.
Yes, sir. Judge, with the court's, with leave of the court, let me have him have a seat. Sure. And I will try to get it done before the end of court.
All right. Thank you.
Thank you. All right, so, sir, go ahead and have a seat back in the courtroom. You may be called back up later. Otherwise, we'll be on for 11/7.
9 o'clock.
Judge, the next I have is Kalani Lewis, 2025 CF 1530. Judge, this is another individual that missed court last Monday, and it was set for today for call to ensure her appearance.
Is there a reason why she wasn't here last week?
Judge, I had told her, as I told Mr. Johnson, I was going to be moving to continuance. I've explained to her that that doesn't mean she doesn't have to be here. It's just telling her what to expect.
Again, Ms. Lewis, just like I told the previous person, I take notes on all these things. So if there's a situation where we have a no-show, I'm going to be less likely to give any grace on that.
I came the next day after the day that I was.
Okay, and I appreciate that, but the big thing is if y'all talk about it and it's going to be continued, you can certainly send me a motion.
I wrote you a letter. I don't know.
Oh, no. Well, just understand that if you write me a letter, it typically goes to my assistant and then it gets filed in the court case, and I typically don't read it and everybody else does. And it's not because I don't care about it, it's because it's ex parte communication. I'm not supposed to read things that you send to me without sending it to the other side too. But just what I'm saying is, as far as filing a motion, just if there's an agreed upon continuance, file the motion, I can sign an order, then she doesn't have to be here.
Yes, sir.
Otherwise, let's get these cases moving. All right. December 22nd, 1 o'clock.
Thank you, Judge. Let's see, Lockhart. Bruce Lockhart. Lockett, I'm sorry. Judge, this is a negotiated plea. State's going to dismiss the felonies.
Okay, that was my notes from last time. Misdemeanor court costs beyond the marijuana and paraphernalia, just 270 still. All right, Mr. Lockett, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. Mr. Lockett, you're here, I'm sorry, state your full name and date of birth, please.
Bruce Edward Lockett, November 15th, 1962.
Okay, and Mr. Lockett, you're here in 25 CF 859, where you're currently charged with possession of a controlled substance, third-degree felony punishable by up to 5 years in prison, and also possession of marijuana, less than 20 grams, and paraphernalia. Both of those are first-degree misdemeanors and punishable by up to a year. Do you understand that?
Yes, sir.
And I've been handing a plea and sentencing agreement that would have you plead to the misdemeanors. You get 11 months, 29 days of probation. In return, the state would dismiss the felony. It'd be $270 court costs, $100 misdemeanor, PD fee, waive cost of supervision. You'll have to do a substance abuse evaluation, any recommended treatment, or comply with the ECLC program, also 24 hours of community service. This would be an adjudication of guilt. Is that what you want to do here today?
Yes, Your Honor.
Is that the state's agreement?
Yes, the state dismisses count one.
Okay. All right, Mr. Lockett, did you go over this plea and sentencing agreement with your lawyer?
Yes, Your Honor.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Say again?
No, sir.
No. Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to take the plea?
No, Your Honor.
Has anyone promised you anything in return for the plea?
No, Your Honor.
Do you understand by entering a plea there won't be a trial of any kind, and you waive your trial rights, which are on page 1 and 2 of the agreement you signed?
Yes.
And do you understand that you're waiving all potential defenses?
Yes, Your Honor.
And do you understand that if you're not a U.S. citizen, you could be deported because of this?
Yes, sir, Your Honor.
All right. Mr. Lockett, what is your plea to the 2 misdemeanors, possession of marijuana under 20 grams and possession of paraphernalia?
Contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given, adjudicate you guilty, place you on probation for 11 months and 29 days, waive cost of supervision, $270 court costs, $100 PD fee, substance abuse evaluation, and any recommended treatment, or comply with the ECLC program, 24 hours of community service. I need you to speak with probation before you leave, Mr. Lockett, and you have 30 days to appeal.
Yes.
Thank you, sir.
All right. Yeah, Judge, I got on the docket, Martine McDonald, Mr.
think he
McDonald
pled.
pled.
I think he pled after we passed him, so it probably just.
Yes, sir.
What did he plead-
Matthew
hold
Murphy.
on a second. What did he plead to? Was it jail?
It was
Okay.
6 months county jail, I think, on a misdemeanor.
Okay, then we don't need him, but I just wanted to make sure that if he was supposed to be released when he pled, that happened. All right, who's this?
Judge, this is Matthew Murphy, 25 CF 1433. Judge, it's a plea to PTI and a plea TI agreement.
All right, Mr. Murphy, you raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
State your full name and date of birth.
Matthew Murphy, 04/16/2002.
Mr. Murphy, you're here in 25 CF 1433, where you're charged with fleeing and attempting to elude, third-degree felony, punishable by up to 5 years in state prison, as well as reckless driving, which is a specified traffic offense misdemeanor that's punishable by up to 90 days in jail. Do you understand that?
Yes, sir.
I've been given a plea and sentencing agreement that would have you plea as charged. The plea is to pretrial intervention. Plea will be held in abeyance pending that successful completion of the PTI. If you successfully complete PTI, your plea will be set aside and the state will voluntarily dismiss the charge. However, do you understand if you're unsuccessful on the PTI, you come back in front of the court and you'll be sentenced according to your guidelines, and then you have a maximum of 5 years state prison and 90 days jail?
Sir.
The terms of your PTI are, it's an 18-month agreement, driver's improvement course, victim impact panel, 50 hours of community service, testify truthfully in 25 CF 1994.
Sir.
Is that what you want to do today?
Sir.
Did you go over this plea and sentencing agreement with your lawyer?
Sir.
Did you understand it? Did you sign it?
Sir.
Are you satisfied with your lawyer's advice and representation?
Sir.
And are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to do this? Has anyone promised you anything in return for your plea?
Sir.
You understand by entering a plea there won't be a trial?
Sir.
You understand you're giving up your trial rights, which are on page 1 and 2 of the agreement that you just signed?
Sir.
And you understand if you don't complete your PTI agreement and you come back, there still won't be a trial, and you'll be sentenced according to what you have. Do you understand if you're not a U.S. citizen, this could lead to your deportation?
Sir.
And what is your plea, Mr. Murphy, to the fleeing to elude and reckless driving? I'll accept your no contest plea as freely, voluntarily, knowingly given. Require you to complete the pretrial intervention program worked out between you and the state, which includes the terms I've already given and are part of the written agreement that you have here. I'm going to have you meet with probation before you leave. And that'll be it, Mr. Williams. You got to give them back the original agreement. Thank you.
Thank you, sir.
Judge, the last one that I have is Zach Neal.
When you say last one, you just mean out of custody, right?
Well, out of
I just want to make sure I'm tracking. Because frankly, some of my people I have for you aren't listed as inmates. I just wanted to make sure I was on the same page.
The last one I know of that's not in jail. Zachary Neal, 2025, 832. Judge, this was passed, I think it's probably the second or third time up. It was passed for me to go over the state's plea offer with him. He didn't want to take it right now, so I'm going to move to continue it. There was an issue with the possibility of a suspended mandatory minimum, and I raised a question as to whether or not that was going to be possible. So I think it's going to...
we've had this discussion, not just us, but in court. I'm not aware of any suspension of mandatory minimums unless the language is specific in the statute. This particular one, I know if it's constructive or actual possession is the issue, but I mean, there's a recent case out of this division from about a year ago that came back on appeal on that issue.
Yes, sir. So I think we need to talk back and forth some more and try to get it worked out. And probably I'm going to need to spend a little bit more time with Mr. Neal once we get that offer finalized.
Just for the record, Your Honor, the offer that was sent, I guess in discovery, calls for 2 years of community control and other requirements. It did not involve any incarceration.
Okay. Is it a firearm that we're talking about? My docket just says possession of a weapon or ammunition.
I'm accessing, yes.
It's actual possession of a firearm by a convicted felon is a 3-year min-man.
It's not charged.
Again?
It's not charged actual possession, and it doesn't have minimum mandatory statute citation in it. It needs to either say actual possessed or have the statute.
That's correct, Your Honor. So I don't understand why he was discussing the 3-year minimum mandatory to
The
begin with.
suspension of it if it's not even part of the plea offer.
Right.
Well, what the state had told me was suspend the mandatory minimum. That's why I put it.
Well, I understand, but so you got what you would want, right?
Yes, sir. Yes,
Okay,
sir.
so is the issue if he goes to trial, then he could potentially, the question is whether or not he can get the minimum mandatory?
As it's
charged?
charged right now, I do not believe so, Judge. I don't think the court would be able to impose it based on my reading.
All right, well, this case is from April, and it sounds like everything's been done other than a resolution. So I'll continue it one last time.
Thank you, Judge.
12/22, 1 o'clock, Mr. Neal. Your case will be resolved next time.
And Judge, I'll check on Mr. Fritz and see if I can
All right, Mr. Powell, you ready?
Judge, back to Robert Kletzger, 25 CF 779. State is agreeing to let them be supervised by JCS. Clients are aware. I have the QR code. They just have to scan that and fill it out.
And what I would do as well, Mr. Powell, based on my own experience too, is document any correspondence, any phone calls he makes to them to make sure he's reporting, because I know they're pretty busy as well, and sometimes the phone calls just don't get through. Again, all of this is about making sure that nothing goes wrong. He ends up getting a violation because of things that we're switching.
Officer Gilbert's contact information.
Okay. And do you have the plea agreement now?
Yes, sir, I do. It would, count one is being amended to petty theft.
All right, this is Robert Adam Kletzger, 25 CF 779. I have a plea and sentencing agreement where the defendant is pleading to an amended count of petty theft, first-degree misdemeanor. It's a withhold of adjudication, 6 months probation, reserve restitution for a period of 90 days. Automatic or probation shall terminate at 90 days if no restitution is owed. Misdemeanor court cost would be $270. May report remotely because he's being supervised by JCS. He needs to be in touch with JCS by the end of today, by the end of the business day. I do have his fingerprints here. That will be filed in the court file with the plea and sentencing agreement, which the court accepts.
Thank you, Judge. I did get made aware that Kletzger's wife actually has a warrant for the same offense. And just letting the state know, I'm going to file a motion to just try to recall that. I don't think.
I wasn't aware of it at all, so once I see the documentation, I'll be able to respond.
Judge, the next matter is Tatiana Migrant. This is the similar situation, Judge. It would be plea to count 3 misdemeanor, counts 1 and 2 would be null pros by the state. Signed plea agreement with.
All right, bring it on up, please. She sent you the actual fingerprint card?
They are in the mail, both.
I just want to make sure that gets filed, because I'm not sure we can accept the printout of it. But
I should
I'm not
have-
going to reject it because of it. I just want to make sure that it gets done.
Thank you. And both originals are in the mail to me.
All right, so this is Migrant, and it's 24 CF 2857. It's a plea and sentencing agreement. State is now processing counts 1 and 2. Count 3 will be a withhold. This is the resisting charge. 11 months, 29 days probation, anger management course, restitution reserved for 90 days. No contact with any victim unless requested by the victim in writing to probation. This is also going to be supervised by JCS. She has to report today to JCS. May report remotely pursuant to JCS rules, and may apply for early termination at 6 months upon completion of all conditions and no violations. And just make sure that fingerprint card, the original, comes in, to be accepted by the court.
Thank you, Judge.
All right, thank you.
Next matter I have is Justin Busby. And it's under Ms. Carter on the docket.
I've got it's number 1 on the docket.
Kind of left it with, plea agreement. I don't know if the state said.
I think it was set plea or trial.
It's ready for trial.
We're ready for trial, Judge. Just, Ms. Carter and I did have some motions to hear. We spoke Friday, or that they would be heard Friday afternoon after jury review. I didn't know if the state.
They've been filed?
They have been filed. I don't know if the state had represented they were going to seek file for child hearsay and a Williams rule. I don't know that those have been filed. They haven't seen them, but those are the pretrial matters that are.
The only problem, Your Honor, the motion that Mr. Stewart and Ms. Carter filed on Friday, I believe it was at 12:59 p.m., is a motion to compel discovery, and that's going to have a substantial impact on whether or not this trial goes forward, quite frankly. The state believes that they don't have any right to what they're asking for, but that's an argument to be held at another time. The court does not have the benefit of that, but I'm just saying it's going to have a substantial impact on the trial.
Case is from October of '23. And I haven't been happy about the last 2 times I've continued it. So why are you just now moving to compel discovery?
Judge, a lot of this came out from depositions.
Which ones?
The last round.
All right, well, you're gonna have to show that to me, Mr. Powell, because what I was been told, and it's been represented to me numerous times, was the last thing that had to be done was one deposition of a particular case officer who they couldn't get in touch with because it doesn't work there anymore. So if it's not based on something that was learned specifically in that deposition, I'm assuming I'm gonna see a transcript at some point.
We did.
The motion compel is gonna get denied. I mean, I haven't read it. You filed it on Friday is what I just got told. You know, in cases that are 2 years pending, this is not how I want to do it. And there's motions for Williams rule or child hearsay.
Well,
These things need to be heard in advance. I don't know why I have to get on this soapbox every single trial period about this. That these, frankly, gamesmanship of filing things at the last minute. Because what I can just do is file these things for the first week, or set these things for the first week of trial. And if the deadlines are not met, then tough. But I'm not going to continue to wait for things to be set for trial. Then now everyone wants to file their motions. It's just not the way it's supposed to be done. 10 days is a minimum. It's not good practice. I'll see y'all on Friday.
But with these, in theory, I mean, are you planning to file?
Well, we thought we had it worked out, but we don't, since you filed this motion, so they will be done.
I guess we need to
We'll do it
put
on
on the
Friday.
record, is there a plea agreement that
Well, we have the discussion not in the middle of the courtroom, sir, sometime, okay? No, there is not right now.
Well, here's the thing. We're set for trial. It's been my policy that I've announced that I don't typically take negotiated pleas after docket day. I mean, I make some exceptions based on things that have changed in the meantime sometimes, but I'm not necessarily agreeing to that at this point until someone explains it to me.
Judge, we did kind of mention that on pretrial, that, you know, I had met with Mr. Busby's family and his Mississippi attorneys met with the family. The state wanted us to get confirmation that he would accept a proposed plea agreement for X number of years. I represented to the court and the state that I was highly optimistic, but I couldn't say 100%. The state was then going to try to speak with the family about extending that proposed plea offer prior to today, and we discussed if we didn't have a deal that he could be waived. Mississippi. So I didn't tell him. I mean,
Is he in custody?
no, sir. He's out of custody in Mississippi.
He's going to be here Friday.
Yes, sir. And we discussed that on the pretrial about you waiving him from today.
I understand. I didn't want him to sit here all week waiting for his trial, but I mean, I'll entertain it as far as, am I going to accept a negotiated plea at jury review? That doesn't mean I'm going to accept it. It means I'm going to look at it and find out why we're here at this late of a date. I mean, there's a way to prepare for cases that goes on 2 different tracks. You can continue your plea negotiations while you're also prepping for trial. And I can't be in a situation of every time the plea negotiations break down, we have to continue trials. That's, again, this case is 2 years old. We've been dealing with the same issues every pretrial, and I want this case over with this cycle.
We've been asking for a plea agreement.
Well, the state's not required to give you one.
But that's what our discussions have been.
Well,
Can we work?
it was set for plea or trial. It's going to be one of the two.
And in theory, Judge, procedurally, just because I know if we are going, the state does have basically all the witnesses are out of state. Is there a way we can kind of finalize the days for trial?
I'm assuming it's the second week at this point.
Yes, Your Honor, that would be our request.
Because I already have a case that's set for the first week. That's going to take up most of the week. Remember, that's also a short week because Tuesday is a holiday. So, but I've got the Douglas case, I believe, is going to be taking up most of the first week. So we're looking at the second week. But we'll address it on Friday. Everyone has to get their witnesses here. The trial dates are well known. My calendar's been published for over a year. In fact, I'm working on 27 already. So let's make sure we're ready.
In theory, we would hear any proposed motions after.
Assuming somebody gives me one of them, sure. But filing these things after pretrial and giving the court no indication of them before today, y'all are playing with fire. All right, we'll see you on Friday at 11/7 at 9 o'clock.
Thank you, Judge.
And I expect any case law that you're going to cite on Friday, if I'm going to hear them, is going to be sent to me as well so I can actually read it and make a determination on Friday.
Thank you, Judge. Have a good day.
Thank you. All right, let's take a 10-minute recess.
Yes, Your Honor. turns out I sent an email yesterday afternoon, right after I talked to this lady. They're, got it done up, okay? It was just sitting in my pen. So I have filed, yeah, still got my half chewed, but, yeah. I'm still gonna need pretrial detention, but I'm gonna go out to the jail.
Is that on Thursday?
Yeah.
Do we have a rank on Thursday? Yeah, I guess we should. We don't?
Pretrial detention.
Well, I'm gonna be at the jail.
I think I have a rank.
I could probably cover it for you, Jay. Probably. Let me look at everything and let you know. But I'm taking a seat then. I should be able to cover it for you, Jay. I don't think I have anything. I definitely on Tuesday. Wednesday, I've got a car appointment.
Yeah, I'm just showing jail visits and pretrial detention here.
Okay, well, either way, I think I'd be able to do it. I'll double check when I get back. We did. I thought we had arraignments. Oh, we did. Do we have arraignments on the 6th, on this Thursday?
Maybe I'm missing
Let me
it.
check.
Yeah, we do. You're
Okay.
absolutely
All right,
right.
I thought I was.
We do?
We just didn't
Okay,
open up
then.
that
Yeah.
far.
I thought I was going crazy.
We need to cover arraignments for you too.
I'm
Well,
open,
arraignments are easy.
Oh, yeah.
you know,
Yeah, just let us know.
Back in session.
Yeah, no worries.
Thank you, everyone. Be seated, please. I think we're taking Ms. Rivers going forward.
I've got two out that
Got
we
two
can
out.
call.
All right, let's take those, but
Calbo. Judge, this is the negotiated plea. This is the gentleman we called up earlier, and he had a quick question for me.
Oh, I'm sorry. What did you say? Where's she down south? Okay. She said she wanted down.
all right. My understanding of the agreement before we get into anything else is it's a plea to a cap of 15 years.
That's correct, Judge, on the unenhanced version of the statute.
As to the DOC, yes, there's no cap on any probation that may follow, but it's a plea to the bench.
And that's correct, Judge, we agree.
And based on that change of the unenhanced versus enhanced, the guidelines go from 128 months to 37.5.
That's correct, Judge.
That's my understanding. Okay. All right, Mr. Calbo, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir. Yes, Your Honor.
Can you state your full name and date of birth, please?
Isaac Dean Calbo, 0124-1993.
All right, Mr. Calbo, you put your hand down. Thank you. All right, Mr. Calbo, you're here in 2024 CF 529, where you're currently charged with 10 counts of an enhanced or possession of certain images of, what's the acronym? Child sexual
CSAM.
activity?
Yes, sir.
Child sexual activity.
Assault. Child sexual
So those
assault.
are enhanced, but the plea calls for it to be the unenhanced possession, which makes it a third-degree felony instead of a second-degree felony, so you can you understand that each of them are 5-year maximum sentences, but the agreement between you and the state would be a 15-year cap of incarceration. Do you understand that?
Yes, Your Honor.
And do you understand, as the state attorney just said, that there would be no cap on the amount of probation I could give afterwards?
Yes, Your Honor.
Okay, and you understand you'd be pleading what we call straight up to the bench, right?
Yes, Your Honor.
So there's no negotiation other than the 15-year cap to the lesser charge?
Yes, Your Honor.
Okay, and do you understand there's still a 37.5-month lowest permissible prison sentence on the guidelines?
Yes, Your Honor.
And that you'd have to go through one of the factors of Florida Statute 921.0026, which is the mitigation, in order to go less than the 37.5. Have you discussed that with him, Mr. Williams?
I have, Judge. I did not cite him to the statute number. I explained that we would have to prove reasons for a downward departure by a preponderance of the evidence.
Okay.
Yeah, I understand that. Sorry.
All right, so you understand you'd have to prove not only that you're eligible for the reasons in the statute I just gave you, but also convince me that I should do that.
Yes, Your Honor.
Okay, otherwise I can't go below the 37.5 months.
Yes, Your Honor.
All right, and it's my understanding we'll set it off for a sentencing where the defense may seek an expert to do a mitigation evaluation, and you'll be seeking that downward departure.
Yes, sir.
All right, is that the agreement that you've made, Mr. Calbo?
Yes, Your Honor.
Is that the state's agreement?
Yes, Judge, it is.
All right, and I have the amended score sheet that shows the 37.5 minimum, or I'm sorry, lowest permissible prison sentence in months. All right, Mr. Cowell, did you go over this plea and sentencing agreement with your lawyer?
Yes, Your Honor.
And did you understand it?
Yes, Your Honor.
Did you sign it?
Yes, Your Honor.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Are you currently suffering from any mental health issues?
That remains to be seen, but no, Your Honor, not.
Say again?
That remains to be seen, but no, sorry. No.
Okay, well, I mean, are you feeling under the influence of any sort of thing now?
No, Your Honor.
Do you understand what's going on here today?
Yes, Your Honor.
And are you satisfied with your lawyer's advice and representation?
Yes, Your Honor.
You understand by entering a plea, there won't be a trial of any kind.
Yes, Your Honor.
And you'd be giving up your trial rights, which start on page 1 and go on to page 2 of the agreement that you signed.
Yes, Your Honor.
You understand that you'd be waiving any potential defenses that you may have.
Yes, Your Honor.
And has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, Your Honor.
Have you interpreted anything that I've said or done that I've indicated what I might do at the sentencing hearing?
No, Your Honor.
Okay, I just want to make sure, because I want to quash that if there is, that you understand. I'll look at everything that's provided to me on the sentencing date and make my decision based on the law and in the areas where I have discretion, based on my discretion.
Yes, Your Honor.
Do you understand if you're not a U.S. citizen, you could be deported because of this?
Yes, Your Honor.
Do you have any questions about your plea agreement?
No, Your Honor.
Do you have any questions about the score sheet you've been provided?
No, Your Honor.
Are there any objections to the score sheet as amended, Mr. Williams?
No, Your Honor.
Okay. All right, Mr. Calvo, what is your plea as to the 10 counts of the possession of certain images involving child pornography?
No contest, Your Honor.
Okay, and you understand those are third-degree felonies, as I've stated?
Yes, Your Honor.
I'm going to accept your no contest plea as freely, voluntarily, knowingly given. It looks like it calls for an adjudication, right?
Yes.
All right, and then we'll set this off for a sentencing based on the agreement, which is a 15-year cap that y'all have worked out.
Yes, sir.
All right. How much time do y'all think you need to set that off?
I'm going to ask for at least 2. We've got to get an expert.
At least 2 what? Months?
Yes, sir. We've got to.
That's fine, I just want to make sure I'm hearing you.
We've got to get at least, get an expert appointed. I'm going to probably use pretty much whoever can get it done quicker.
State, any concerns about dates?
We have no concern about that. It does look like there's a January 8th arraignment date. I don't know if there's also miscellaneous on that date or not.
I think I've tried to put miscellaneous on every arraignment date now, because
Okay.
otherwise we just don't have enough time to get through all these things.
Okay.
I would be a little concerned coming so close after the holidays, because people tend to take vacations and stuff like that over holidays. I don't want to.
Must be nice.
Well, I'm going to be here with you, Judge, and so I won't be, but just in case either Dr. Zeman or Dr. McDonald are going to be out of the office, I don't want to.
Well, let's put it on that January 8th at 2 o'clock. If you contact whichever doctor you're going to use, Mr. Williams, and they indicate they may not be able to get it done on time, we can certainly continue it ahead of time. I'd rather not do it at the last minute.
Yes.
Because, as you know, everyone prepares for these things. Can you all approach for just a second?
Yes, sir.
Five 683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing.
All right.
Hometown roofing.
So, Mr. Calbo, we'll see you back on January 8th at 2 o'clock for purposes of sentencing.
Thank you.
Thank you, Judge. Judge, I'm also in a position.
I'll get fingerprints on that date.
Judge, I'm also in a position to bring Mr. Krivek up. I had sent an email so that would be in her inbox this morning, and she has already drafted the reciprocal. It was in my pending in stack. I have approved it, made copies, or downloaded copies, and sent it to your email and to the assistant state attorneys.
I received it during the recess, I saw it.
I've seen it, Your Honor. I was preparing my motion.
And what is the basis of your motion? Not the basis, what type of motion will you'll be
To
filing?
exclude testimony of this because irrelevant. Yeah.
Well, we can address that on Friday. I just don't really have any days before then. I guess we have a little bit on Thursday. I just don't know how that would work. I'm not sure how many we have on Thursday afternoon.
Judge, just to be clear on 2 things. One, I'm requesting continuance in the matter because of the new witness.
I understand, but if I ultimately deny or grant the state's motion to either exclude that witness or, then we'll go forward on the trial. I don't like the idea of postponing trials because of a maybe.
Are we going to have a hearing on the 7th, in which case I'll subpoena this lady to be present?
That's fine if that's what you'd like to do. I don't have the motion yet. I don't know what we're dealing with yet. And again, you just filed this during court today. And again, I'm not being critical of you, Mr. Williams, because you just talked to this witness. But this is a 16-month-old case where
Yes.
new witnesses are being provided that seemingly no one knew about or actually have been told to you before, but you couldn't get in touch with until just now. I don't want this to be the reason why we continue cases. All right, we'll see you back on 11/7 at 9 a.m.
Thank you, Judge. Be in court Friday, sir.
We doing in custody, out of custody, or does it matter? Okay, all right, that'll be fine. Diana Malone. 21 CF 923. Malone, you need to sign your plea agreement. Mm-hmm.
Okay.
Mm-hmm.
Okay.
Remember the questions he's got to ask you? Yep, all right. Just sign it right there. All right. Then I'll sign it. Did I give you the score sheet before? No? I'll just change this.
Yes.
I'm gonna ask you questions to make sure that.
All right. Just to make sure I understand, I think we talked about it last time, but just to keep it on the record. The plea is for 19.65 months in the Department of Corrections. But my understanding is Ms. Malone's been continually in custody for over 4 years?
Yes, Your Honor.
Is that right?
Yes.
All right, so even though it's 19.65 months, she's, would have credit for probably over 50 months at this point.
Yes, Your Honor.
Okay. All right, Ms. Malone, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, can you state your name and date of birth, please?
Diana L. Malone,
Okay,
11/20/62.
and Ms. Malone, you're here in 21 CF 923, charged with robbery without a weapon, second-degree felony, punishable by up to 15 years state prison. Grand theft, third-degree felony, punishable by 5 years in state prison. Aggravated animal cruelty, third-degree felony, punished by up to 5 years in state prison. Tampering with evidence, third-degree felony, punished by up to 5 years state prison. And misdemeanor battery, 1 year maximum as a first-degree misdemeanor. Do you understand that?
Yes.
I've been handed a plea and sentencing agreement that would call for you to plead no contest to those charges. In return, the state's offer that you be adjudicated guilty, 19.65 months in the Department of Corrections with credit for serving over 19.65 months, $622 in court costs, $100 cost of prosecution, $100 PD fee, and a $50 application fee. Do you understand that?
Yes.
All right, do you understand that you'd be adjudicated of all those counts? So there's 4 felony convictions.
Yes.
Okay. Is that the state's agreement?
It is, Your Honor.
Has the state had the opportunity and taken the opportunity to reach out to the victim in the case?
The state has, yes, Your Honor.
Okay, and have they given you their opinions on this?
I'm sorry, Your Honor.
Have they given you an opinion on the plea offer you've provided?
They were okay.
They're okay with it? Or they're not here?
Oh, no, they're out of state.
I think
Your
you
Honor.
told me that last time, but I'm just making sure for the record.
Yes, Your Honor.
Okay.
I discussed it.
Okay. And this is a guideline sentence, correct?
Yes, it is.
All right, Ms. Malone, did you go over this plea and sentencing agreement with your lawyer?
Yes.
Did you understand it?
Pretty much.
Are there parts of it that you didn't understand?
I don't know. We'll see.
Well, this is the time to figure that out, because if
Yeah.
you don't understand it, I've got to make sure you do before I accept it.
Yeah.
Is there a particular portion of the agreement that you don't understand?
No.
Okay. Is there some general issue with it that you don't understand?
No.
I'm going to ask you some more questions, but if
Okay.
something pops up that you're not quite sure about, you've got to ask me now.
Okay.
All right. Did you sign the agreement?
Yes.
Are you satisfied with your lawyer's advice and representation?
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues or concerns?
Yeah, I take medication.
Okay, are you currently on that medication?
Yes.
Do you feel like you know what's going on here today?
Yes.
All right, Ms. Rivers, have you had any concern with her since she's got back?
No, Your Honor.
Okay. And I previously found that you were competent to proceed. Do you understand that?
Yes.
Okay. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything in return for your plea?
No.
Do you understand by entering a plea there won't be a trial of any kind?
Yes.
All right, and do you understand that you're giving up your trial rights?
Yes. Yes.
All right. And I'm going to go through a couple of those with you so I make sure that you understand what you're doing here today. Do you understand you're giving up your right to plead not guilty?
Yes.
Do you understand you're giving up the right to a trial by judge or jury?
Yes.
Do you understand you're giving up your right to be represented or helped at a trial by your lawyer?
Can you repeat that, please?
Sure. I'll say a little slow. Sometimes I get
Okay.
so used to it, I can do it pretty fast.
Okay.
Do you understand that you have the right to be represented by a lawyer if you were to go to trial?
Yes.
And they'll help you at that trial?
Yes.
All right. Do you understand you have the right to compel or make witnesses come to trial for you?
Yes.
And do you understand you have the right to be present when witnesses testify against you?
Yes.
Do you understand you have the right to cross-examine witnesses who testify against you? Through your lawyer would do that. They would ask the state's witnesses questions.
Yes.
Do you have any confusion about that?
No.
Okay. Do you understand you have the right to remain silent and not testify against yourself?
Yes.
Do you understand you have the right to present any and all defenses that you may have?
Yes.
Do you understand you have the right to appeal all matters, including the issue of guilt or innocence?
Yes.
Do you understand that you have the right to file motions to suppress evidence? Asking the court that the state couldn't use particular pieces of evidence in the trial.
Yes.
And you understand you have the right to testify on your own behalf at that trial.
Yes.
And you understand that you have the right for your attorney to further investigate the case, including locating and deposing any potential witnesses.
Yes.
All right, do you understand that you're giving up all of those rights by taking this plea?
Yes. Yes.
Do you have any questions about that?
No.
You understand that you're waiving any potential defenses that you may have?
Yes.
And do you understand if you're not a U.S. citizen, you could be deported because of this?
Yes.
All right. And Ms. Malone, what is your plea to the robbery without a weapon, grand theft auto, aggravated animal cruelty, tampering with evidence, and battery?
No contest.
All right, I'm going to accept your no contest plea as freely, voluntarily, knowingly given. According to the agreement, you'll be adjudicated guilty, 19.65 months in the Department of Corrections, with credit for serving over 19.65 months. As I've stated, you've been
Yes.
in state custody for over 4 years. Is that correct?
Yes.
$622 in costs, $100 cost of prosecution, $100 PD fee, $50 application fee. I'll give you 90 days to either pay those or set up a payment plan with the clerk to pay those. Anything that I've missed?
No, Your Honor.
This is a guideline sentence, as 19.65 months was her guideline according to the score sheet.
Malone, thank you.
All right, I'll need you to be fingerprinted, Ms. Malone, and then you have 30 days to appeal this judgment and sentence.
Okay. Thank you, Your Honor.
Thank you. For this case, yeah, I don't know if there's anything else holding, but assume not.
Your Honor, this is Denisha Ross, 25 CF 1363. You had asked me to contact Dr. Sheehan to figure out why she had not been evaluated. I did reach out and talk to Dr. Sheehan. She had indicated she wasn't aware of the evaluation, although there was the download. So based on the discussions with her and with Ms. Ross, we are going to use Dr. Zeman going forward. And we'd asked to have this put on the 12/23 docket.
December 23rd, 9 o'clock for your next pretrial. Whatever you can do to expedite that, Ms. Rivers.
Yes, Your Honor, if we get it done sooner, we'll bring her in sooner.
Thank you.
Thank you. And I do have some out of custody. Oh,
Thank
okay.
you, Ms. Ross.
Your Honor, this is James Strickland before the court on 25 CF 864. And we're set for trial.
Yes,
Okay, so
sir.
ready for trial?
Yes.
All right, Mr. Strickland, still ready for trial? Are there any pending motions or soon-to-be filed motions?
Not from the state.
Okay.
I just want to state for the record that we share the vet record, and we got a hold of the doctor now, so we're sharing it.
Any concerns about days for the trial? Do we think it may be more than a day?
Excluding jury selection, no, Your Honor, just one day.
We can talk about it more, obviously, on Friday, but if we have a one-day trial y'all want to try to put on next Friday, we can certainly do that. I know you've got a larger trial right before that, Ms. Leone, but I just don't want to end up using up that day. Maybe pick the jury on Monday and go Friday. I'm not necessarily saying Mr. Strickland, but just to make sure we're using as many days as we can.
Yes, Your Honor.
Okay. All right, Mr. Strickland, we'll see you back on Friday, November 7th at 9 o'clock, just to see if we can get that coordinated as your final trial date during the trial period of the 2 weeks.
Okay. Your Honor, the next on the docket, going back, is James Mullen, 24 CF 2918. We had previously filed a not guilty by reason of insanity, and the state was going to talk to the victims to decide how she was going to go forward.
All right. Ms.
Yes,
Leone?
they are officer victims. I have not been able to speak with them. If I could ask to keep the case for Friday, I can attempt.
And we're not set for trial, right?
That's
No,
not,
no.
no, Your Honor.
November 7th, 9 o'clock for status.
Yes, Your Honor. Your Honor, the next one is Jared Mullis, 24 CF 2840. I do not see him in the courtroom. I was unable to speak with him. He does have another criminal matter ongoing.
Is that here?
No, Your Honor.
Where's it at?
Mississippi.
Mississippi. I won't be able to look that up then. Was he here last week? Wait, he wasn't here last week when we set it for trial?
Your Honor, he had filed a waiver.
I'll ask for a capias, Your Honor.
Any reason why I shouldn't give a capias, Ms. Rivers? No legal basis?
No, Your Honor.
All right, be a capias, no bond on Mr. Jared Mullis. Be taken off the trial docket.
Next is Sapreet Parmar, 25 CF 1161. Your Honor, she was presented with a PTI. I believe she understands the PTI, but there is some confusion with the legal terms and how the legal process works. So I'm going to bring her in my office to go over the legal process. And I've spoken.
Plead a PTI or just PTI?
Plead to a PTI. So I'm going to bring her into my office and kind of go over things some more with her. I've spoken to Ms. Basso about it. We're going to ask for the 1222.
That's without objection, Your Honor. The offer for the PTI remains open.
12:22, 1 o'clock. Stay in touch with your lawyer so that y'all can have that conversation, and we'll see you back on that day.
Your Honor, the next one is Brianna Plank, 25 CF 1027. We've reached an agreement in this matter, Your Honor, if I may approach.
Yes. This is IHSS.
In-home support services, Your Honor.
ECF involved?
They were early on, I believe, Your Honor, but they're not right now. This case has been around for a little bit. The recommendation was for the in-home support services to take the place of that and to provide the support Ms. Plank needs.
And I understand it's lesser included 2 counts of misdemeanor battery, but there was only 1 count to begin with, right?
Yes, Your Honor, we'll have to file an amended information that will reflect the 2 counts.
That's what I wanted to make sure of. All right, Ms. Plank, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, can you state your full name and date of birth?
Brenda Michelle Plank, January 16th, 1998.
All right, and Ms. Plank, you're here in 25 CF 1027, where you're charged with 1 count of child neglect, which is a 3rd-degree felony and punishable by up to 5 years in state prison. I've been handed a plea agreement that calls for you to plead to 2 counts of misdemeanor battery. Be consecutive, 11-month, 29 days of probation. On each count to be served consecutively, as I said, so you basically have 2 years of probation. Do you understand that?
Yes, sir.
Ms. Plank, you'll have a mental health evaluation and complete any recommended counseling, complete the parenting class, and cooperate and or participate in any in-house
In-home support services,
in-home
Your Honor.
support system. I mean, I've been through 3 years of dependency in 3 different counties. I've never heard that acronym before, so. All right, the in-home support services. All right, waive cost of supervision, 622 in court costs. It says times 2, but wouldn't it just be per case?
Yes, Your Honor.
So, but there's only 1 case.
Good point, Your Honor.
$50 PD fee, $50 application fee. Going to be an adjudication of guilt. Do you understand all that, Ms. Plank?
Yes.
Is that what you want to do today?
Yes.
Do you understand the state's going to have to file an amended information that lists 2 counts of battery because you only have 1 count of child neglect at this time?
Yes.
All right, so that'll come later, but I just want to make sure you understand that. Have you gone over this plea and sentencing agreement with your lawyer?
Yes.
Do you understand it?
Yes.
Did you sign it?
Yes.
And are you satisfied with your lawyer's advice and representation?
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Are you currently suffering from any mental health issues?
Yes.
Okay, do you understand what's going on here today?
Yes.
Are you currently medicated for that reason?
Yes.
Are you currently taking your medication as prescribed?
Yes.
Okay. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything in return for your plea?
No, sir.
You understand by entering a plea there won't be a trial?
Yes, sir.
You understand you're giving up your trial rights, which are on page 2 of the plea agreement that you signed?
Yes.
And do you understand that you'll be waiving any potential defenses that you may have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could subject you to deportation?
Yes, sir.
And what is your plea to the 2 counts of misdemeanor battery 78403?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. The 2 counts of misdemeanor battery, I'm going to adjudicate you guilty on both. You'll be sentenced to 11 months, 29 days of probation on each count to run consecutive. Like I said earlier, so that'd be basically 2 years of probation. You'll have to do a mental health evaluation and complete any recommended treatment, complete a parenting class, and cooperate or participate in the in-home services, waive cost of supervision, 622 court costs, $50 PD fee, $50 application fee. I'm I'm gonna need you to be fingerprinted because they're battery charges and enhanceable. And I need you to talk to probation before you leave, and you'd have 30 days to appeal.
Yes, sir.
Your Honor, the next one is Misty Salters, 25 CF 1264. Ms. Salters is present and approaching. We had asked to put it on for this date to see if the state could make contact with the victim. Okay. And maybe it would be better if we just put it on the next, on the 12/22 docket.
December 22nd, 1 o'clock, Ms. Salters. Hopefully we'll make some progress at that point. All right. Have a good day.
Absolutely. The next one is Donald Simmons, 25 CF 703. In this particular one, we had set it for trial. The state had asked, last time, the state had asked to continue it to set a deposition. Then Mr. Sheik got activated. Then Ms. Leone had asked to put it on for today.
And I would offer paraphernalia for time served.
Do you? No, you? He would like to accept the offer, so if the court would give us a few minutes and we can write that up.
Sure, that'd be perfect. Thank you, Mr.
Okay.
Simmons. She's going to go over some paperwork with you once it's drafted, and then I'll call you back up to plead yes.
Yes, sir.
All right. Your Honor, the next one after that would be Lauren Valmajoa. She is present and approaching. She is here on a failed PTI.
Was she here last week?
No,
No.
That's why we put it today, right?
that was the one where she, when you looked at it, it showed she didn't get notice, the notice
That's
came
fine. I
back.
just wondering why it got to docket day as opposed to something else.
Yeah, and I told you that I had good contact information and I would make contact, and I did.
All right, so was it a diversion pursuant to a plea?
Yes, Your Honor.
Okay, so it just needs to be set for a sentencing hearing? Have y'all talked about a subsequent agreement? I'm not requiring you to, but I just want to know if that's been done. That is a no. I don't know anything about the case other than what the charges are, looking at my docket, so do y'all want to set up for a sentencing hearing?
Yes, Your Honor.
How much time would you need for that?
Well, the terms are already,
Oh, are they?
yeah.
not finding the plea agreement, I'm just finding the diversion. Clerk minute sheet from back then says PTI would plea, but I don't see a plea agreement.
We had the same issue in another case with Mr. Maddox.
That's correct, Your Honor.
I'm not sure why the plea's not there.
Sometimes, for one reason or another, Your Honor, I guess they don't get filed, but I don't know why. But I've seen it happen a couple
I don't
times.
know why either. I wasn't around back then. So.
It may have also been done orally, for whatever reason.
Now, this is Ms. Glisson's. Ms. Glisson always does a two-tier process. She does a written PTI, and then she also does a written plea agreement with the terms of the written plea agreement. She does two. That way there's no confusion because people were saying they didn't realize they were entering a plea. She does both.
That's how most of the ones we've done today were.
Yeah.
And I think it's the better practice, but I'm just trying to find a plea.
Oh, yeah, I know.
This is the only case I'm finding. And there's a different case with Mr. Maddox?
Yes, Your Honor, Cheyenne Dowell, although we'll.
Oh, a
discuss that
different
later.
case that has a
That's-
similar situation?
Yes, Your Honor, but that's been
Okay.
dealt with by us where the court looked it up
So
and
I'm
made
trying to
some.
look up to see her other case.
No.
Problem is, if there's no written record of it.
Yes.
I'll have to go back and maybe watch it. It will tell us. We can get a transcript from it, but all I can see is PTI with a plea, and there's no plea agreement.
Well, maybe if Your Honor would continue it to look into that, and maybe Ms. Valmajoa could try to do her DUI class.
I mean, 988. But everything is just, that's just the pretrial diversion, but there should be a plea that she entered in order to get into the diversion. On a miscellaneous date, so I can go figure that out and come back and tell you what it said.
Yes, Your Honor,
Okay.
but don't rush.
Say again?
I said, but don't rush.
I don't know how I could rush, because it's, Thursday wouldn't be enough time for me to actually spend the time doing it. And then we've got 2 trial weeks, so we're probably talking, and then I think it's Thanksgiving, so I think it's December 4th. Probably we put it on the morning on December 4th. December 4th at 9, just because I know the afternoon is, I think, got a lot of contested things. And then I'll review it in the meantime.
Hang out before you leave. Okay? Yeah.
All right, we'll see you back on that date, ma'am.
Your Honor, I got one more. That's Jordan Rodriguez, 25 CF 992. Your Honor, she is going to enter into the pretrial intervention agreement. Let me approach.
Is it a plea or no?
Yes, Your Honor.
You have a plea agreement? I'm certainly not going to do something that's going to put us in the same situation we just had. If it's gonna be a plea to PTI, I'm gonna need a plea agreement. Otherwise, every time there's a failure, I don't wanna go back and look it up. And by look it up, I mean, go back, hopefully being able to find the video in the system when it's a year or two old, and not have to go get it from archives in order to determine what happened on a case that pre-exists my assignment to this division. So if we could write that up, I'll certainly take it today. I just need the paperwork to be all there.
Yes, sir. If you'll give us a few minutes, Your Honor.
Yes.
How many?
I've still got some out of custodies to call, Your Honor, whenever we get to them.
Why don't we do this? I want to get the out-of-custody people done. I'd like to get the private lawyers done. Mr. Kleins, if you have limited things, I can get you done, but we got to take a break at some point. It's 12:15.
Yes, Your Honor.
I'm not going to take a long break. I'm not going to take a full hour or anything, but Mr. Cobb?
I have 3 out of custody, please. Marty, do you have 3 out of custody?
Okay, we can handle them all. I just want to. I just don't want to get in a situation where we go till 2, 3 o'clock and we haven't taken a lunch break. And if y'all want to take a lunch break sooner than going through these, I'm fine to do that too. I'm just trying to get people out of here, especially if they've been waiting all day.
Lonnie Ward, State v. Lonnie Ward, 2024 CF 2269. Judge, this is Mr. Ward, present before the court. He's going to withdraw his plea of not guilty and enter a plea of no contest to the amended charge of possession of fentanyl with intent to sell, manufacture, or deliver. The terms of the plea agreement are as follows: adjudicated guilty, 5 years probation, substance abuse evaluation, any recommended treatment, or he can complete the ECLC program, 100 hours community service work, no alcohol or drugs, maintain employment or 5 applications, and 8 hours of community service per week while not employed, standard court costs, probation fees, and cost of prosecution. May I approach?
Is that the state's agreement?
It is, Your Honor.
Mr. Ward's also asked if I could ask the court. He's basically unemployed, doesn't have any income, and is going to need some help with these costs. I know there's going to be court costs. He's asked that I can get that waived, probationary fees. He's asked if I can get that waived, but if we can't waive the cost.
Were you appointed, Mr. Coe?
Yes, I was appointed.
I'll waive cost of supervision. That's typically what we do in indigent cases where they're represented by the public defender, RCC, or an appointed private lawyer. As far as costs, I mean, he's got 5 years of probation to do
He'll
it.
do the best he can do.
I mean, part of the requirements are to get a job or apply for 5 of them a week.
Yeah, and I told Mr., he's also requested that if he's successfully completed probation, 2 years of probation, he's asked me to file a motion to terminate. I told him he has the right to file a motion to terminate, and then if he successfully completed it within 2 years, I would do that for him, but I couldn't guarantee that that would be granted, but I definitely will file that for him. If he's done 2 years without any, technical or new substantive violations.
I'll only be here for another 2 years and 2 months or so. So I might not be here by the time, so I don't want to lock in whoever takes over this division then when I move back to family law. I mean, you could certainly, like you said, file the motion and see what happens, but typically, and I think under the statute talks about doing half of the probation, so. All right. Mr. Ward, can you raise your right hand? Do
Yes,
you
sir.
swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your name and date of birth?
Anyway, Ward, February 15, 1966.
Okay, Mr. Ward, you're here in 24 CF 2269 where you're currently charged with trafficking in fentanyl, which is a second-degree felony and punishable by up to 15 years in state prison. Do you understand that? I've been handed a plea and sentencing agreement that would have you plea to an amended charge of possession of fentanyl with intent to sell, manufacture, or deliver, which is then a third-degree felony punished by up to 5 years in state prison or 5 years probation. Do you understand that? All right. Have you gone over this plea and sentencing agreement with your lawyer?
Sir.
Did you understand it and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea? Or is the early termination, is there anything that I've done to make you
No,
think
sir.
you're going
You've
to?
been good. You've been
Mr.
good.
Ward, if you could let me
Yeah,
finish.
much respect.
Mr. Ward, if you could let me finish. I have to say the complete thing, and then you answer, otherwise the record gets a little bit muddy, and it's hard to understand exactly what gets said. I don't want someone to come back after me 2 years from now and say, we couldn't tell what you said, Judge, because y'all were talking at the same time. All right. So, Mr. Ward, was there anything that I did or said that made you think that I was going to grant it or deny
No,
it?
sir.
Okay. All right, do you understand by entering a plea, there won't be a trial of any kind?
Yes, sir.
And do you understand you're giving up your rights to a trial, which are on page 2 of the agreement that you signed?
Yes, sir.
And you understand you're waiving all potential defenses?
Yes, sir.
And do you understand that if you're not a U.S. citizen, you could be deported? All right, and what is your plea to the lesser included charge of possession with intent? I'll accept your no contest plea as freely, voluntarily, and knowingly given. I'm going to adjudicate you guilty, sentence you to 5 years of probation. You're to complete a substance abuse evaluation and any recommended treatment, or you can comply with the ECLC program. 100 hours of community service work, no alcohol or drugs, maintain employment, or 5 applications and 8 hours community service work per week while not employed. Is that 8 hours of the 100, or is that additional?
If he hasn't completed the 100, they're part of the 100. And then if he does complete it, and he's not employed, he would have to do 8 hours a week.
All right, so is that your understanding of the agreement, Mr. Ward?
I understand.
Okay, so you're going to do 100 hours of community service regardless.
Yes, sir.
If after you finish the 8 and if you're not working, you have to continue to do 8 per week or 5 job applications per week while you're not employed. You'll also get court costs of $515. Probation fees will be waived due to the fact that you're indigent and represented by public counsel. Cost of prosecution, I believe, is included, but also $150 basic public defender fee. If I missed anything.
No, Your Honor.
All right. Mr. Ward, I'm going to need you to get fingerprinted because it is a felony conviction. Then I need you to talk to probation, and you have 30 days to appeal the judgment and sentence.
Okay, Judge, the next case I have is James Jr. Jackson, 2024 CF 2486. Mr. Jackson is present in case number 2024 CF 2486. He's charged with 1 count of child neglect without great bodily harm and obstruction of the services of execution of a warrant. He's going to withdraw his plea of not guilty, enter a plea of no contest as charged. In count 1, he's going to be adjudicated guilty and placed on probation for a period of 36 months. He'll have a substance abuse evaluation and any recommended treatment, no drugs or alcohol, random UAs and/or breath testing. There'll be home inspections without notice, and he's got to comply with the DCF case if there is a DCF case, and complete a parenting class with regards to count 1. With regards to count 2, he'll be adjudicated guilty and sentenced to credit for time served. This plea form's a little bit, I have to make some adjustments. I apologize. Can I approach?
Yes, sir. Thank you.
Asked probationary fees to be waived to help him out some.
This would be a downward departure.
Yes, Your Honor, it would, based on a legitimate uncoerced plea.
Mr. Ward, can you keep it down a little bit? All right. Mr. Jackson, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your full name and date of birth, please?
James Jr. Jackson,
All right,
52378.
Sorry, I interrupted you. Go ahead.
James Jr. Jackson.
No, you're fine.
Oh.
You're fine. I'm just saying I didn't mean to interrupt you. I started talking before you finished. That's my fault. You're here at Mr. Jackson, 24 CF 2486, where you're charged with child neglect, third-degree felony, punishable by up to 5 years in state prison. And then we have the obstruction of service or execution of a warrant. I don't have a degree or max on that.
That's an M1, Judge. and
M1?
It should be on the score sheet as well.
Okay. Yes, it is on the score sheet, but it was on the plea and sentencing, so I'm just going to add that.
Thank you, Your Honor.
No problem. All right. So the obstruction charge is a maximum of 1 year in county jail. Do you understand all that, Mr. Jackson?
Yes, sir.
Okay, Mr. Jackson, I've got a plea and sentencing agreement that calls for you to plea as charged. On count one, you'd be adjudicated guilty, 36 months of probation. And count two would be credit for time served. You got some special conditions that your attorney read off. Did you understand all those?
Yes, sir.
Okay. Is that what you want to do here today?
Yes, sir.
All right. Have you gone over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it all?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Anyone promise you anything in return for your plea?
No, sir.
You understand by entering a plea there won't be a trial of any kind?
Yes, sir.
And do you understand that you'll be giving up your trial rights, which are on page 2 of the agreement that you signed?
Yes, sir.
You understand you're waiving all potential defenses?
Yes, sir.
Do you understand that if you're not a U.S. citizen, you could be deported because of this?
Yes, sir.
And what is your plea as charged to the child neglect and obstruction of execution of a search warrant, or of a warrant?
No contest.
I'm going to accept your no contest plea is freely, voluntarily, knowingly given. On count one, the neglect case is adjudication of guilt, 36 months of probation, substance abuse evaluation, and any recommended treatment. You don't use or possess any drugs or alcohol. Random urinalysis for the detection of those things. Random breath testing for the detection of the alcohol.
No notice home
No
inspection.
notice home inspections, and comply with any DCF case if you have one.
You have
There's
to
also a
complete
parenting class. All right, I'm just trying to make sure I got it all, Mr. Coe.
Yeah, I was just worried you wouldn't be able to read my writing.
The handwriting's fine, it's just kind of going in different directions. And on count two, Mr. Jackson, it's going to be an adjudication of guilt, credit for time served. Your court costs total would be $666 for both counts. That'll be a $150 PD fee. I'll waive cost of supervision due to the fact that you've been found to be indigent. This is a downward departure based on the state's agreement to an uncoerced plea bargain.
Sir, thank you.
All right, Mr. Jackson, I'll just need you to be fingerprinted, then talk to probation before you leave. You have 30 days to appeal.
Justina Eastwick. Judge, this is Justina Eastwick, present before the court in 2025 CF 1266. She's going to withdraw her plea of not guilty and enter a plea of no contest to one count of child neglect without great bodily harm as charged. The terms of the plea agreement are as follows. There'll be a withhold of adjudication of guilt. She'll be placed on probation for a period of 18 months. She'll have a substance abuse evaluation and any recommended treatment, no alcohol or drugs, random UAs and/or breath tests to detect those substances. She'll be subject to no-notice home inspections, and she's supposed to comply with any DCF case if there is one, but I don't believe there is one open up at this time. Can I approach?
All right, Ms. Eastwick, can you raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
Justina Nicole Eastlake, 7/4/1989.
Okay, and Ms. Eastwick, you're here in 25 CF 1266 with a 1 count of child neglect, third-degree felony punishable by up to 5 years in state prison. Do you understand that?
Yes, sir.
All right, I've got a plea and sentencing agreement with terms that your attorney just announced, 18 months plus all of those conditions. Did you understand all that?
Yes, sir.
Is that what you want to do today?
Yes, sir.
Have you gone over this plea and sentencing agreement with Mr. Cobb, your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
And are you satisfied with Mr.
Yes, sir.
Cobb's representation? You've seen a bunch of these today. I know you all been here a while. But are you satisfied with his representation?
Yes, sir.
And are you currently under the influence of any alcohol, drugs, or controlled substances?
Absolutely not.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressure, or threatened you to do this?
No, sir.
Anyone promised you anything in return for your plea?
No, sir.
You understand by entering a plea there won't be a trial of any kind? You understand you're giving up all your trial rights, which are on page 2 of that agreement you signed?
Yes, sir.
Do you understand you're waiving all potential defenses?
Yes, sir.
Excuse me. And do you understand that if you're not a U.S. citizen, you could be deported? Okay. All right, and what is your plea to the 1 count of child neglect?
No contest.
All right, that was the state's agreement, correct?
Yes, Your Honor.
All right, I'm going to accept your no contest plea as freely, voluntarily, and knowingly given. I'm going to withhold adjudication, place you on probation for a period of 18 months. You're to do a substance abuse evaluation and any recommended treatment. Don't use or possess any alcohol or drugs. Random UAs and breath tests for detection of those substances. You're subject to no notice home inspections, and you have to comply with any DCF case plan if there is one. Also, court costs will be $666, $150 PD fee. I'll waive costs of supervision due to the fact that you've been declared to be indigent and are represented by publicly appointed counsel. Any questions, Ms. Eastley?
Yes, sir.
All right, thank you. I don't need your fingerprints because it's a withhold, but I do need you to speak to probation before you leave. Then you have 30 days to appeal. Thank you, ma'am.
All right. Those are my out of custodies. Well, what time do you think I should come back to do the in custodies?
How many inmates do you have? No, for Mr. Cobb.
2.
Just 2, and are we doing anything other than are they both trials?
It could be a little difficult, both of them.
Okay, then why don't we have you come back, just say 1:30 to be safe, because we got a few more to go, and then we're going to take a little bit of a lunch break.
Yes, sir, Judge. Thank you.
All right, thank you, Mr. Cobb. Mr. Nopes, did you have a couple?
I do. I've got Mark Dandridge.
Sign right there. May I approach, Your Honor?
Yes, sir. So I know, Mr. Nopes, when you've got count 2 be null prossed up here, has it already been null prossed or it is part of the plea?
She's going to announce it.
Okay, I just wanted to make sure. All right. Mr. Dandridge, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sir.
All right. Can you state your full name and date of birth, please?
Full name is Mark A. Dandridge Jr., sir. Date of birth is October 20th, 1983.
Okay, Mr. Dandridge, you're here in 25 CF 756, where you're currently charged with possession of a concealed weapon by a convicted felon, second-degree felony, which is punishable up to 15 years in state prison. You also have a possession with intent charge, which is being null pros. Do you understand that?
Yes, sir.
Okay, and then you've got some misdemeanor cases, or not cases, but counts, attaching a tag not assigned, no valid driver's license, and possession of drug paraphernalia. Do you understand all that?
Yes, sir.
Okay, I've been handed a plea and sentencing agreement that would call for you to plead to counts 1, 3, 4, and 5. Count 2 will be null pros. You'll be adjudicated guilty. On count 1, it'd be 3 years probation, 515 court costs, 150 court-appointed legal assistance fee, substance abuse evaluation, any recommended treatment. Is that, and then, or could be ECLC, or is it both?
Judge, the way she said it, it included both of them. That's what I wrote out.
All right. It'll be both, and then 100 hours community service work, which you can buy out, maintain gainful employment, or apply to 5 jobs per week. And then on the 3 misdemeanors would just be adjudication and time served.
Yes,
Is that
sir.
what you want to do today, Mr.?
Yes, sir.
All right. Did you understand the plea and sentencing agreement?
Yes, sir.
Did you go over it with your lawyer?
Yes, sir.
Okay. Did you sign the agreement?
Yes, sir.
Okay. And are you satisfied with your lawyer's advice?
Yes, sir.
State this would be downward departure.
Yes, based on uncoerced plea and need for treatment.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
All right. Have you been forced, pressured, or threatened in any way to enter this plea?
No, sir.
Have you been promised anything in return for your plea?
No, sir.
You understand by entering a plea there won't be a trial of any kind?
Yes, sir.
You understand you're giving up your trial rights, which are on page 1 of the agreement you signed?
Yes, sir.
And do you understand that if you're not a U.S. citizen, that you could be deported?
Yes, sir.
All right. What is your plea to the possession of a concealed weapon by a convicted felon, attaching tag not assigned, driving without a valid driver's license, and possession of drug paraphernalia?
No contest, sir.
All right. I'll accept your plea as, of no contest as freely, voluntarily, knowingly given. State I have an announcement on count 2.
State dismisses count 2.
Count 2 is dismissed. As far as your sentence on count 1, be adjudication of guilt, 3 years probation, 515 court costs, 150 court-appointed legal assistance fee, waive cost of supervision, substance abuse evaluation, any recommended treatment, comply with the ECLC program, 100 hours of community service work, which you can buy out at the statutory rate, maintain gainful employment or apply to 5 jobs per week. On the 3 misdemeanors, it's just going to be adjudication of guilt on all of them and time served.
Yes, sir. Thank you.
All right, Mr. Dandridge, I'll need you to speak with probation. You also need to be fingerprinted, and then you'll have 30 days to appeal. This
Yes,
is
sir.
a downward departure, just barely, but it's a downward departure based on the need for treatment and an uncoerced plea agreement. All right, thank you, Mr. Dandridge.
Judge, the last case I've got is Terrence Parker.
All right, just Mr. Dandridge, your court costs will be $548 instead of $515, just a little bit different. I'm sorry, go ahead.
Yeah, so Mr. Parker, Judge, I have checked with my office, and they've indicated that we do have the deposition scheduled, but they believe that they're set currently in January. What I'd ask the court to do is just to continue this to the December 23rd pretrial, I think is your next one.
Yes, sir.
Then we'll verify that we've got depositions. We'll firm that up. We may just have to come back and ask you to continue it first.
All right, you understand that, Mr. Parker?
Somewhat.
Is there any questions you have for the court at this point?
County jail almost 13 months. I mean,
How long have you been on it, Mr. Notes?
Judge, I got involved February, and again in April. I got appointed to another, I guess that was the newer case.
The March case.
ready to get this over with, honestly. Like,
Has a plea offer been conveyed?
Judge, they've made a plea offer. He doesn't want to accept it. It's 15 years.
All right, Mr. Parker. I'm going to put you on December 23rd at 9 o'clock. I'd like for this case to get close to a resolution, if not resolved on that date.
Sir,
Are you
thank you.
coming to bring that stuff?
I'm sorry?
Are you coming to bring that?
Listen, maybe not today because I got caught up in court this morning, but by tomorrow. All right.
You have someone else lined up? Who is Mr. Kleinsen?
Three. Two legal.
Are they gonna, is the third one gonna be?
There's gonna be a
Okay. Let's do them. Ms. Leone, did you get that email about our sentencing for Thursday?
Yeah, I did. I'm not sure.
You could talk to Mr. Keach and find out what we're doing that day. I don't want to talk about it any further than that, just for scheduling purpose. I just want to know if that's still
Yeah,
going to happen.
yeah, no, I haven't spoken with him.
Okay, well, I know, we just got it. I got it 6 minutes ago.
Me too, yes.
Just so I know what we're doing that day.
So go ahead and sign. Sign and date both of them. Your Honor, this is Mr. Brown. He's signing, actually, the way I had written this up was with two different plea agreements because there are two VOP cases and then a new law violation with 5 charges, actually. At this time, Mr. Brown is signing a plea agreement to resolve the 24 CF case, the new law violation. He's also signing a plea agreement to resolve both of the 22 CF. Today is 11-3, to resolve both of the violations. In the 22 CF cases, Your Honor, Mr. Brown, let me pull this out real quick. Mr. Brown is going to be admitting that he violated supervision in 22 CF 1420 and 22 CF 1823. The agreed upon disposition for those two cases is that Mr. Brown's supervision will be revoked and terminated. He would be assessed a $100 cost of prosecution for each case, a $100 cost of defense for each case. All of the outstanding financial obligations will roll into a new period of supervision that Mr. Brown is going to be placed on in 24 CF 2757. In that particular case, Your Honor, there was an amended information charging 5 counts. Mr. Brown is going to be entering a plea as charged on counts 1 through 4. In exchange for that, count 5 will be dismissed. Counts 1 and 2 in 24 CF 2757 are both third-degree felonies, possessions of controlled substance. Mr. Brown will be placed on 24 months of probation concurrent between those counts. The reason why he's entering this plea, Your Honor, is that Mr. Brown must attend and complete the Chrome treatment program. I talked to them this morning. There is a bed available. His mother is in court. So just like we did with Mr. Marshall last week, who did report to the program, I confirm that.
Where's Chrome? Is that the one in Marianna?
It's in Marianna, yes, sir. Mr. Brown must report to the program no later than 5 p.m. on 11/4/25 on counts, and I screwed up the plea agreement, Your Honor. It should say just counts 3 and 4. I put 1, 3, and 4, but on counts 3 and 4, those are misdemeanors. Mr. Brown will be sentenced to time served. He would be assessed $615 in court costs in 24 CF 2757, $50 in public defender fees. If I didn't say it, he would be adjudicated in both of the 22 CF cases. He has previously been adjudicated. May I approach?
Yes.
And I will confer with Ms. Leon if there's some issue with the score sheet, so we'll submit that separately. And I'll do the work on that to make sure that the numbers are correct.
Is a guideline sentence?
It's a departure sentence, Your Honor. It will be a departure sentence.
Based on?
Need for treatment uncoerced plea agreement.
Probation have any issues with rolling financial obligations in his probation VOPs into the new case?
No, sir, we don't, Your Honor. I mean, the likelihood of him getting them paid instead of just going ahead and putting new collections now, I don't know the reason, but.
Mr. Brown is going to be going to trucking school, so license suspensions are something he can't deal with. So that's why I wanted them to be rolled into the new probation period, so he can work on paying those off as part of probation.
I'm going to take the plea in the new case, and then I'll roll them in once you
Yes,
go to
sir.
probation on that. All right, Mr. Brown, can you raise your right hand? Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Brown, you're here in your first case is 24 CF 2757. We are currently charged with 2 counts of possession of a controlled substance. Those are third-degree felonies, punishable up to 5 years, and then 3 misdemeanors, which are possession of marijuana, possession of paraphernalia, and DUI, which are all up to a year in county jail. Do you understand that?
Yes, yes.
You understand that's what you're currently charged with?
Yes, sir.
Okay. I've got a plea and sentencing agreement for that case that would have you plead as charged as to counts 1, 2, 3, and 4, with count 5, which is the DUI, to be dismissed.
Yes, sir.
And as your attorney announced on counts 1 and 2, it would be 24 months of probation, attend and complete the Chrome treatment program. You must report to that program no later than tomorrow, November 4th. And then on counts 3 and 4, it'd be time served. You have a total of 615 court costs, $150 PD fee, and I waive cost of supervision. Is that all right, Mr. Kleins?
Yes, sir.
Okay. Is that what you want to do, Mr. Brown?
Yes, sir.
Did you read through all of this?
Yes, sir.
In your agreement, did you understand it?
Yes, sir.
You satisfied with your lawyer?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
And anyone force you to do this?
No, sir.
Anyone promise you anything in return for your plea? You understand there's not going to be a trial of any kind if I accept your plea? Do you
Yes,
understand
sir.
you're giving up all your trial rights, which are on page 1 and 2 of your agreement?
Yes, sir.
Do you understand you can be deported if you're not a U.S. citizen?
Yes, sir.
All right, and what is your plea to the 2 counts of possession of controlled substance, possession of marijuana under 20 grams, and possession of paraphernalia?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. State to have an announcement on count 5.
State dismisses count 5.
It'd be adjudication of guilt on all 4 counts that you pled to. Count 1 and 2 be 24 months probation. Concurrent with each other, you must attend and complete the Chrome treatment program. You must report to the program no later than, is that 5
5
p.m.?
p.m. Yes, Your Honor. I know.
5 p.m. on November 4th of 2025. That's tomorrow. So once you get released, you got to get there tomorrow by 5 o'clock, Mr. Brown.
Yes, sir.
Counts 3 and 4 will be time served. I have a total of 615 court costs, $150 PD fee, waive cost of supervision. I'm still waiting on the score sheet, but I've been told it's going to be a downward departure based on the need for treatment as well as an uncoerced plea bargain. And then, Mr. Brown, you also have your VOPs, which are 22 CF 1420 and 22 CF 1823. I have a plea agreement that would call for you to admit that you violated your probation, $100 cost of prosecution times 2, $100 cost of defense times 2, and all your other, all of your financial obligations that are outstanding would be rolled into your probation that I just placed you on. It'd be a revoking term of this supervision. Is that what you want to do?
Yes, sir.
All right. Did you go over this form with your lawyer?
Yes, sir.
Same questions. You understood it?
Yes, sir.
You satisfied with your lawyer?
Yes, sir.
You're still not under the influence of any alcohol, drugs, or controlled substances?
No, sir.
All right. Anyone force you to do this?
No, sir.
Anyone promise you anything in return?
No, sir.
You understand there's not going to be a hearing where the state would have to prove you violated your probation?
Yes, sir.
All right, and what is your plea to the violation of probation? Are you admitting or denying that?
Admit I violated.
All right, I'm going to accept your admission as freely, voluntarily, knowingly given. $100 cost of prosecution times 2, $100 cost of defense times 2, and all of your financial obligations that are outstanding will be rolled into the probation that I just put you on in 24 CF 2757. Revoke and terminate this current probation on these cases. Anything that I've missed?
No, sir.
Everyone understand what just happened?
Sir.
Okay. All right, thank you. You have to be fingerprinted on the new case, Mr. Brown. I need you to speak with probation. You have 30 days to appeal.
Yeah, this is Mr. Haynes. She's present and approaching. I had left him on today's docket the same way I left Mr. Brown on, hoping we could get a resolution. We can't. However, I do think we're making some progress, so I would ask the court to continue this one cycle. If we do get a resolution here, we will advance it. Just so the court's aware, we've made a new counteroffer last week that the state is not in a position to accept it now, but I'll keep talking to Ms. Leone. If we can get this resolved, we'll move it up a docket, certainly.
These are both new cases? By new,
They are.
I mean not VOPs?
They are. So Mr. Hanish was out on bond in the 24 CF case, and then in January of this year picked up the new charge in the 25 CF case.
24 cases from May of 24.
I understand, and that's why I'm saying I want the court to be aware. We've proposed a counteroffer of Department of Corrections time with some supervision on the back end for some treatment. I'll keep talking to Ms. Leone about that.
All right, Mr. Hanish, we'll see you back on 12/23 at 9 o'clock. See if we can get this in for a landing next time.
December 23rd. It's on there, it's right there. December 23rd. Yep, but I'm gonna come see you
Yes, Your Honor.
next couple
We
weeks.
withdrew.
Okay. Last I have this morning, Your Honor, is Mr. Byrd. We were just appointed to Mr. Byrd's case last week. I met with him at the jail on Friday. This case is going to definitely have to be continued. So I would ask for a one-cycle continuance to the 23rd.
What number did you say it was? 38. 38, there it is. Yeah, I've got it crossed off with your name on it, so. All
That's
right,
gonna
you
be
want the
our next
23rd?
Yes, sir.
All right, 12/23 at 9 o'clock, Mr. Byrd. I just appointed Mr. Kleins to your case like last week.
Yeah.
We just wanted to make sure you get a chance to meet up with him, and I'll put it on our next available pretrial conference of December 23rd, 9 o'clock. All right, thank you, sir.
Thank you.
Thank you, Mr. Kleins. Anybody else out of custody?
Yes,
In
Your
out
Honor.
of custody? Out of custody? All right, let's resolve those, and then we're going to take our lunch break. Run out of gas here.
All right, first I have Madeline Cass, Your Honor, 25 CF 1386, was set for a plea today. She called our office and said she had a work training thing. So I did waive her appearance today, Your Honor. We put her on 12/4. We'll bring it home for resolution on that date.
Sign a waiver of appearance?
No, not signed, Your Honor. I just filed one on her behalf, though.
You said this is Cassidy?
Yes, Your Honor, Madeline Cassidy. She's just going to plea.
When do you want to do that?
12/4, Your Honor.
Can I do it Friday?
I could reach out, certainly. We could put her on that date tentatively.
Let's put it on for 11/7, see if we can get it resolved.
Certainly.
It's a one-day work thing, we can resolve it then.
All right. I'll reach out to her, Your Honor. Steven Cordova. Your Honor, I've got no information on him. He was supposed to sign his plea agreement today per his request. This was the gentleman whose grandmother passed away, if I do recall, so that is unfortunate, but I've not heard
I
from him
continued
since.
it so he can go to the funeral and not be on probation, and
Correct.
they didn't show up for court.
Yes, Your Honor.
APS bond.
Oh, Mr. Cordova? Hey, sir. All right. There we go.
Did you not see him today?
I did not. Were you here earlier this morning?
No, I thought I was supposed to be here at 1.
Have you
I don't
gone
know.
over the paperwork with him?
Yes, Your Honor. This is the same plea agreement that we went over last time. I just need a new signature because it's a new plea agreement. That I typed up. I lost the other one.
Still on your probation.
Yeah,
Okay, that's it.
as charged.
Yeah.
I don't know what it is about what I'm gonna date that for you. Apparently, anything I say, people tend to do the opposite of, so maybe I should try the other way. Status charge for the driving license suspended. Average.
Mr. Cordova, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
State your name and date of birth, please.
Stephen Cordova, 8/22/92.
All right, Mr. Cordova, you're here on 25 CF 1531, charged with felony drive-on license suspended, punishable up to 5 years in prison as a third-degree felony. Do you understand that?
Yes, sir.
I have a plea agreement here that would call for you to plead as charged, adjudication of guilt, 11 months, 29 days probation, 515 court costs, $150 cost of defense, waive cost of supervision. Is that what you want to do today?
Yes, sir.
You can put your hand down, sir. Have you gone over this plea agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
You satisfied with his advice?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand if you enter the plea, there won't be a trial, and you've waived your trial rights that are on page 2 of the agreement you've signed?
Yes, sir.
And you understand if you're not a U.S. citizen, you could be deported?
Yes, sir.
This is a guideline sentence. What is your plea to the drive-while license suspended felony?
No contest.
Accept your no contest plea as freely, voluntarily, knowingly given. Adjudicate you guilty, so that's a felony conviction, 11 months, 29 days probation, 515 court costs, 150 cost of defense, waive cost of supervision due to the fact that you've been declared to be indigent. I need you to be fingerprinted and then taught to probation before you leave. You have 30 days to appeal.
Thank you, Your Honor.
Thank you, Mr. Mayor.
You're welcome, sir.
Oh, 548 court costs, so just a little bit more.
For the
Just
is
traffic.
it always 548 for the driving charges? 'Cause I'll fix that.